box. So we are expected to do this. So we have another image here. This is from Reverend Jerry. Thank you so much, sir, for attempting. One of your dots is left out. Of course, you have how many lines? 1, 2, 3, 4. You have 4 lines, but 1 dot is left out. Please try again, sir. Thank you so much. Wow, this is almost like, this is from Gloria. It's almost like that of Mr. Jerry. Please try again. One of your dots is left out. Of course, it's 4 lines, but all the dots are supposed to be connected. Thank you so much. Okay. And this is from Salamatu. Thank you, Salamatu. This is your 3rd attempt. This is actually encouraging. I want to really appreciate you for putting in effort to make sure that you get the puzzle correctly. So I'll not comment on yours yet. Let's see what we have. Okay. Thank you so much, Salamatu. This is from, let me get the name correctly. Choma. Okay. Thank you, Choma. Please, we are all expected to attempt the puzzle. Please just send in your answer, no matter how it is. We will look at it together and then see those that got the answers correctly. So your dots are actually joined together, but let's count the lines. You have 1, 2, 3, 4. Are we sure? Let me count again. 1, 2, 3, 4. Okay, it's 5 lines, of course. Okay, it's 5 lines I will have there. Choma. This is 1, 2, 3, 4, and 5. Your lines are 5. They are supposed to be 4. 4 lines. If you are just joining us, we sent an image. Okay, I think let me just resend the image for those that are just joining. So that, okay, somebody is referring and me to another image. Let's view it. Okay. This is from Cordina. Thank you so much, ma. Your dots are actually connected, but your lines are not together. And how many lines do we have here? We have 1, 2, 3, 4. Okay, 1, 2, 3, and 4. But your lines are supposed to be connected. It's not supposed to break. As you can see here, the lines are not connected, and this other end, the lines are not connected together. Thank you so much for the attempt. Please try again. We have about 3 minutes more to go. Please send in your answers. This is from Salamatu. This is from okay, we have another image here. This is from Victor. Thank you so much, Sir Victor. Wow. This is interesting. You have to connect. Your lines are so much. I don't even know how to count them. 1, 2, 3, 4, 5. You have to use just 4 lines, sir. Just 4 lines to connect the 9 dots without lifting your pen. 9 dots to connect the 4 lines. Please, if you have any question, feel free to ask. We have another image here. This is from that chum. Sorry if I didn't pronounce the name correctly. Thank you so much for your attempts. Please try again. 1, 2, 3, 4. You have 5 lines there. And your lines are supposed to be connected together. They are supposed to be together. Just 4 lines connecting the 9 dots together. Thank you so much. Please, if you are yet to carry out this exercise this morning, please do so. Like I said, I keep emphasizing, you have difficult cases before you, difficult disputes. You just have to think outside the box to be able to help the client to resolve. So to be able to come up with options that you can present to the clients, and then they'll be able to accept and also resolve the dispute before you. So we are all expected to carry out this activity. Thank you so much, Sir Dachon. Please try again. We are yet to get it. For those that I have gotten it. I'll mention the names later on, but for the sake of giving others the opportunity to also carry out the activity, I'll not comment on yours yet. So please. Wow, this is from Eunice. Thank you so much, man. This is your second attempt. Think outside the box. Connecting four dots with just 9 dots with 4 lines, I mean to say. Connecting the 9 dots with 4 lines. We have 1, 2, 3, 4, 5. We have 5 lines here. Thank you so much, man. This is from Gloria. Okay, this is from Gloria. Thank you so much for attempting the puzzle. Thank you so much. Please, we just have it's 10 already. So please, for those that still attempting, just send in your answers so that we review them together before we commence on the lecture properly this morning. Thank you so much. Good morning and good afternoon and good evening to you, depending on your time zone. Okay, I think if you are just joining us, we are actually going through our check-in activity this morning. I sent an image to the WhatsApp platform. We are supposed to connect 9 dots with 4 lines without lifting pen. Without lifting our pen. So far, so good. We have gotten some answers coming in. Thank you so much, Mulika. Thank you so much, Ma, for attempting and the puzzle before us this morning. You are expected to connect the 9 dots with 4 lines without lifting pen. And here we have how many lines? 1, 2, 3, 4, 5, 6, almost 6 lines. So please, we're about rounding up, please. This is from Helen. Thank you so much, Helen. Okay, thank you so much for attempting the puzzle. So just briefly, I want us to give a round of applause for Gloria. She actually got it correctly. Gloria and Masalama actually got it correctly also. She made attempt up to 3 times and she got it correctly. Yeah, and then I have somebody here also. I didn't comment on theirs earlier on because they actually got it. I just kept it so that I'll save it for the last. And this is sorry, let me go back to it. This is from, sorry, please. Our facilitator for this morning is around. I just want to let's view the last. This is from Sarah. Actually, she was the first person that got the answer correctly. Please, a round of applause for her. A round of applause for Sarah. Thank you so much, Ma. Sarah got it correctly. Salamatu got it correctly, and Gloria got it correctly. All females. We are the men in the house. Well, thank you so much for going through the check-in activity with me this morning. I'll also send in my own answer from my end on the platform so that we'll get to all do it together. So I'll want to call on our speaker this morning, Mafoluke. Please, you can go ahead, please. We know our facilitator this morning. She has been with us right from day one. Our first speaker, she has been the first speaker all through the training, right from day 1, day 2, and today she's here with us. Ma, please, the podium is over to you. Thank you so much.
Thank you very much, Ma. Good morning, good afternoon, good evening to all of us all. I hope that we've
Jolly
been
good morning, ma'am.
Good morning. I hope we've had a great time so far. Good
I'm
morning.
excited to be with you again.
Morning, ma.
Good morning, ma.
Thank you. Thank you so very much. Thank you so very much. And happy Labor Day. May our labors be prosperous and fruitful by the grace of the Almighty God. Amen.
Amen.
Okay. Sorry, Ma, can you kindly stop screen share so I can share my screen?
Okay. All right. All right. I want to also use this opportunity to appreciate Mr. Samuel. I saw him. Thank you so much, sir, for joining us this morning. Mr. Samuel, thank you so much. Please go ahead, ma.
Okay, so let me just try and do my screen share now. Please let me know once you can see my screen. Can we see my screen now?
Not yet, sir.
Not yet, ma.
Yes, ma. I'm seeing it.
Yes,
Active listening
okay.
and question
Now,
technique.
yes.
Okay. Okay, so fantastic. Today we're going to be talking about active listening and questioning techniques. So at the core of every conflict is communication. Even between mammals and animals, you see that sometimes they want to create territory and all, and they do that by fighting or by, taking certain steps to declare their boundary. And that is even at that level. How much more when it comes to human beings? So today we're going to be looking at what effective communication in mediation actually means. How do you ensure that as a mediator or as a dispute resolution practitioner, you are able to get your points across, essentially, and you're able to help the parties to effectively communicate with each other? Because ultimately, if the parties are not listening to themselves, there is no point trying to get them to amicably resolve their disputes. And so in talking about effective communication, we're going to be looking at active listening. We're going to be looking at effective skills for a mediator. We're going to be looking at non-verbal methods of communication, which is going to be more of a practical session than a session, more of a practical session than I having to do all the talking. And then we're going to be talking about questioning. And this is a very important tool in the hand of the mediator because like the good book will say, deep calleth unto deep. The more structured the question is, and the more result-oriented a question is, the more effective the answers will be in channeling the parties' minds and averting the parties' minds to the possibility of resolution. If the mediator is not skilled in questioning techniques, it can result in a mediation impasse. And we're going to be talking about how mediations can end up essentially not resulting in settlement, but in even in some instances in even more complex disagreement than what the parties had before they came to mediation. So at the root of every conflict or dispute is ineffective mediation. So I remember yesterday we spoke about behavior, experience, subject, object, the subject being the people, the object being the scenario or the activity that led to the issues, and it is the subject, it's a combination of the subject and the object leading to the experience that would then result in the behavior that culminates in the dispute, and if escalated, results in a conflict. Now, at the heart and at the root of the object, the object and the interactions between the subjects is communication. Whether it is verbal or it is non-verbal, it is communication. In relationships, it is also communications as well. So what is communication if it is so important in the mediation process? Communication is the process by which people attempt to share meaning via the transmission of symbolic messages. Please, can we kindly mute if we're not speaking? Thank you very much. And so communication involves trying to understand how people relate to one another. So based on cultural nuances, there are different ways in which people relate to different people. So for instance, in certain parts of Nigeria, a younger person must not look eye to eye with an older person when they are talking. In other parts of Nigeria, a wife would kneel to give her husband his food. In other parts of Nigeria, before you come into the Oba's palace or the king's palace, you must be ushered in. You can't just walk in like that into his presence. So communication is a process where meaning is shared. So if I say to another person, my name is Fuluke Akimoladu, what I'm essentially doing is telling the person how the person is to identify me. This is the name by which I am to be known or identified with. So it is verbal communication. My name is Fuluke Akimoladu. And it is transmitting the meaning that this is the identity by which I am to be known by, or this is the identity that defines my person. And so communication requires having to transmit meaning. So ultimately, on the other hand of it, it means that ineffective communication is where the meaning intended to be transmitted is not transmitted. So if I say, my name is Foluke Akimoladu, and the person says, no, but I saw you driving a different car, you can see that there's ineffective communication. The person is assuming in their mind that I was talking about a car. Meanwhile, I was assuming in my mind that I'm telling the person what my name is and how the person is to address me or is to call me if they need my attention. So in that particular scenario, you have ineffective communication. The meaning that I've intended to pass across is not the same meaning that the other person is receiving. Now, communication involves shared meaning, which suggests that people communicating must agree on the definitions of the terms they're using. On the face of it, we must understand that communication is subconscious. What that means is that we don't consciously have to handle communication. In other words, we speak without necessarily having to think about every letter and every word we're going to say. Now, does that mean that we should speak without thinking? No. But it's important that we understand the power of the subconscious with our communication. So an example is you come from an area in Nigeria where younger people don't look you eye to eye in talking to you. You then travel abroad, and then somebody who is probably the age of your child is having to talk to you face to face, and you feel offended. Meanwhile, the person is just trying to communicate based on their own understanding of how people speak to other people, not necessarily having to have that informed by age. And so you see different languages even have different names for different experiences. So for instance, in the Yoruba language, you have a different way of addressing an older person and a different way from addressing a younger person. The English language doesn't have any of that. And so it's possible that if you're speaking to an older person, if you're a Yoruba, if you're from the Yoruba speaking parts of Nigeria, and you want to communicate that respect in English language, you now have to borrow other words like ma, or lower your tone so that the other person knows that you are trying to still depict that level of respect, even though the tools of the language, of the English language, may not necessarily be adequate to address it on the same level that you would have when you are speaking in Yoruba. Now, communication is symbolic. You have gestures, you have sounds, you have letters, you have numbers and words, and they only represent or approximate the ideas they are meant to communicate. So when we're talking about things like verbal communication, we can talk about what we say, and then we can talk about written communication as well. There are certain ways in which letters are written that it could send a different message to the receiver from what the sender was intending to say. And so you see someone say that the person defamed me, or that the person wrote something libelous against me. And that may not have necessarily been the intent of the person who generated the content of the letter that the other person is now seeing as libelous. And so it's important to understand that at the core of it, communication is symbolic. It is communicating some form of symbols, gestures, sounds, letters, numbers, and words to communicate the ideas to that one person is trying to communicate to the other person. So communication essentially commences from your thoughts. It is what you think of saying, it's what is the thoughts that have come into your mind that is then used as the basis for what the meaning that you are trying to pass across to the other person. That is essentially what communication is. And it's very important for us in the dispute resolution space to understand the flow of such communication, because like I mentioned earlier, at the core of every dispute, at the core of every behavior, at the core of every experience, at the core of every dispute that has escalated into a conflict is a miscommunication. Now, communication can be verbal or it can be non-verbal. The other things that we need to understand about communication is that for communication to happen, there must be a sender, somebody who is sending the message, somebody whose thoughts has put the message into some form of meaning. There must be a sender, then there must be a receiver, somebody who is receiving that message. So a monologue is generally not communication until it becomes some form of dialogue. So if you're talking to yourself, it's not necessarily communication. But if another person comes to hear or know or comes to experience that particular meaning that you are trying to communicate, then communication has happened. Then there must be a message. So it's one thing for there to be a sender. It's one thing for there to be a receiver. There must be a message that the sender is sending to the receiver. Like I mentioned, communication is symbols. It has to have some form of meaning. Otherwise, you are not communicating. And it has to have a meaning that the person who is listening to you can identify based on their nature and their experiences. So for instance, if I'm speaking to someone who doesn't understand English, it doesn't matter how articulate I make my words, that other person cannot understand because the ability to make sense of the symbols in this particular scenario, the sentences I am making, has hindered the ability to communicate. So yes, I may be speaking well, I may be articulate and all, but the person I'm speaking to does not understand what I'm saying. So communication is not happening because the other person does not have a meaning based on their own experience or understanding of languages or understanding of communication to receive the meaning that I'm trying to pass across. It's the same way if someone is speaking Spanish to me, for example. I don't speak Spanish. And so if the person is speaking, no matter how well spoken and how articulate the person may be, the fact that the person is speaking Spanish and I do not understand Spanish, I cannot consciously or subconsciously make out a meaning on what that person is saying, except in the cases of non-verbal communication. I will come to that in a bit. But as far as verbal communication is concerned, that other person has not been able to communicate with me because I don't have a background or an understanding capable of making meaning of what the other person is trying to tell me. Then there must be a channel. So if it's verbal, the channel, of course, is your mouth. If it is written, the channel is the paper. It could also be emails. It could also be fax in the days of fax. If it's verbal, it could be your mouth, it could be the phone, it could be a voice note, depending on what you used to get the message across. And then you have feedback. Feedback helps you to know whether or not the person has received. So feedback allows the sender to know that the receiver has received the message through the channel that the person has sent it to. So an example, I send a voice note to somebody on their phone. The channel is the phone. The message is the voice note. But I didn't get any feedback. I didn't get any response. And then I see the person a few days later and I said, well, I sent you a voice note about this thing. And the person said, I didn't see it, which means that the channel was not effective in passing across the message. So there was a sender, there was a receiver, there was a message, but the channel wasn't effective enough to get the message across. And so there was no feedback. So that could happen maybe when you have a network issue and the person, because of that network issue, was not able to receive the message being sent and give feedback in the circumstances. So we now move on to active listening. Now, there are 5 main elements of active listening. The first is to pay attention. Oops, sorry. So if for a mediator to help the parties to be able to communicate effectively, you have to be an active listener. In other words, you need to know what are the issues that brought up the issues. You need to know the thoughts behind the thoughts. You need to be able to essentially ensure that you are hearing what the parties are saying behind what they are saying. So like the example I gave yesterday about a stock market dispute that ended up being a family dispute, it required that the mediator was actively listening to some things that may not have necessarily made sense in the capital markets scenario. Another example is when I handled a mediation between members of a family that had to do with whether or not they could sell their mother's property. And their mother was one out of 4 or 5 wives of the father. There are 54 children of the father, but the wife, who was the first wife, had 9 children. And those 9 children were disputing whether or not to sell the mother's property. But on further probing, and I'm sure we'll be taking through the different stages of mediation later on and talk about exploration and probing stage, it became obvious to me and of course the parties that the main reason why the issue of selling the property was coming up was because the last born had more or less, for the lack of a better word, mismanaged the resources available to him. And so in order to make up for that, he now started instigating other siblings against themselves, telling them, you will do better with the resources that will come from selling our mother's properties and the likes. Now, the older ones did not buy into it. And they were of the opinion that, look, our mother left something for us. We should leave something for our children. We should add to it. We shouldn't have to sell it. And so if as a mediator, you are not paying attention, you would think that it is just an issue of them having to manage resources. You would not understand that it is actually one person who is instigating the others. That left to them, they really didn't want to sell the properties. And so being able to identify that influencer that is causing this antagonism helped to be able to isolate the issues. And at the end of the day, we then found out that there was even already a court judgment which had enforced a Sharia, because the man is a Muslim, that enforced a Sharia law, court decision on how the property should be distributed under Sharia law. Now, if one was not attentive to hear and note that, okay, this is the person who is antagonizing, one would not have been able to ask those questions that eventually led us to understand that, look, there was already a judgment that had distributed this property. And in that judgment, the distribution of the property did not involve selling the property. It only involved sharing the proceeds of that property. So as a mediator, it's very important to pay very close attention. No, so you give the speaker your undivided attention, acknowledging the message. And so things like having to nod your head, tilting your head to one side so that the person knows that you are listening to them. Because if you keep staring at somebody without maybe your eyes moving, or you're looking at the person and you're looking away, the person will think you're not listening to them. So pay attention. Then show that you're listening. Use your body language and gestures to convey your attention. Nod occasionally, smile, and use other facial expressions. Being able to smile can help the flow of communication a lot. So as mediators, please let us try not to stay all stone-faced such that the parties are not sure whether they are standing before a judge or before a mediator. The mediator should be welcoming. I'm not saying allow the parties to make you feel like you're a clown. That's not the point. But at least make the parties comfortable enough to be able to say what they want to say in your presence. And this is particularly important in family mediations where there's so much emotion and there's so much bottled up feelings. You don't want to add to the heat in the room by having an unfriendly and an unwelcoming countenance. Then provide feedback. When a party says, I wish he had not taken the children out of the house, we then asked, did he take the children out of the house? You already know that he did, but you are providing feedback to show that, one, you're listening, and two, you want the person to be sure of what they are saying. Because sometimes out of the emotional upheaval that a person is feeling, they may not necessarily know what they are saying. And so you need to be sure that the person knows what they are saying by providing feedback. So our personal filters, assumptions, judgments, and beliefs can distort what we hear. So as a listener, especially as a mediator in the process, your role is to understand what is being said. This may require you reflect what is being said and ask questions. So like the question I asked, are you sure he took the children out? Now, that he took the children out can have many meanings. Number one, it could be he took the children out outside the arrangement that we had. Number two, it could be he took the children out without my knowledge. Number three, it could be he took the child to take them to somebody I didn't want the children to be familiar with. There are so many implications of that one simple sentence. And so your job as a mediator is to ensure that, one, to assure yourself that you are not allowing your own biases to come in, but two, and more importantly, is that you actually understand what the person is saying. Because as a neutral third party in the mediation, yours is to help the parties to see where the communication has broken. So if in the example that I gave, the wife, in saying that he took the kids, is a bone of contention between them, and the man is saying, yes, I took the kids, but I only took the kids to go and watch the movies so that we could have fun together. I've traveled for a long time. I've not seen them for a while. I know we're having issues, but I still want to be a father in the lives of these children. So you can see that on the one hand, the woman is thinking the man is trying to manipulate the children against her. And on the other hand, the man is thinking this woman is being unreasonable. I'm hardly there for these children. And the one time I decided to take them out, she's gone all ballistic about it. So as the mediator, it's your job to say, Mrs. A, Mr. A is saying now that he took the children to go and enjoy themselves so that he can spend some time with them, that he had traveled for a while. Did he tell you that? And you know, it is now for the wife to say, oh, I didn't see it that way, or that wasn't what I understood it to be. So you can see that you have essentially unlocked one of the ineffective communication issues between the two. And in unlocking all of those communication blockers, you begin to open up the possibilities of peaceful and amiable resolution. Then number 4, deferred judgment. Interrupting is a waste of time. When a party is speaking, except you are trying to clarify or you're trying to be sure of what you're saying, don't interrupt, because it frustrates the speaker and limits a full understanding of the message. So if you have a situation where you have like a power imbalance between the parties, the party that feels like the weaker party in the scenario would want to be less communicative. They want to speak less because they don't want anything to further hinder the situation that they feel that they are in. And so it is important that you defer judgment. Don't come to conclusions. That's really what judgment means. Don't come to conclusions so easily. Allow the parties to explain themselves, if you may, in such a way that it creates clarifications for the parties, not just for yourself, but also for the parties. Because again, you have to be careful not to be seen as a judge. You are not a judge. Your job is to help the parties to amicably settle. And in doing that, you have to be careful how your tone and your words come across, especially when you're asking questions for clarification. Then number 5, respond appropriately. Active listening is a model for respect and understanding. You are gaining information and perspective. So in my mediations, especially when I handle banking mediations, I tell the parties, look, I wasn't there when this loan agreement was agreed to. And so these questions I'm asking not to make the parties uncomfortable, but to have a better understanding of how the banker-customer relationship started, and in so doing, help both of you to see the options and the possibilities for settlement. Now, the mediator is known as the neutral diplomat. Essentially, what you're trying to do is to be firm but sensitive. So you're controlling the mediation process because you must control it. You can't allow the mediation to go haywire. I remember one of our colleagues mentioned a mediation where she was which she was handling, and one of the parties, who was an elderly man, got so emotional he jumped on the table and started, shaking his fist to get his message across. Please be in control of your mediation. Once you see that the tension in the room is rising, just call for an adjournment, or it could be a short break. If you say, you know what, I think there's a need for all of us to catch our breaths, to take in all that has been said so far. Can we just have a short adjournment for about 10-15 minutes? And everyone leaves the room. You've essentially dispersed the energies that have risen in the room that could possibly create a mediation impasse. And as a mediator, you need to be sensitive about when the temperature in the room is rising. And what I mean by that is when you can sense that everybody is getting all tensed up and is willing to do things that ordinarily in their right minds they would not have done. Like my dear elderly gentleman who decided that the best way to get his message across was to jump on the table. Then the mediator must demonstrate deep knowledge and understanding of human nature. What that means is we're not asking you to be a psychologist. We're also not asking you to be a psychiatrist, because you are not supposed to recommend how people should continue with their lives. That's not your job. Your job is to help the parties to see their own options and then use those options to amicably settle the dispute between them. Now, even in evaluative mediation, where you as the mediator acts more or less like an expert neutral to help the parties to generate options. And this usually happens with lawyers who are mediators and accountants who are mediators, or professionals who are mediators. even in those scenarios, ultimately, the options that the options that will be used to resolve the dispute has to be the options the parties have agreed to. And so it's important, have a deep understanding of human nature, know when things are seeming out of whack, for lack of a better word, and be conscious of the emotions in the room. Be conscious of any emotions of anger, any emotions of hurt, any emotions of regret, any emotions of confusion. Be very conscious of the emotions in the room. I know that one of our facilitators will be taking emotional intelligence. It's extremely important for a mediator to have emotional intelligence. You need to be able to identify the emotions in the room and your own, and also checkmate your own emotions to ensure that in scenarios where you may have someone who has gone through what one of the parties have gone through, or maybe you've gone through it yourself, you do not essentially put yourself into that scenario. I remember handling a banking mediation where a senior mediator was involved. And even though he's known as one of the best in the field, in that particular mediation, he was extremely emotional. And so it's important for us as mediators to continuously, subconsciously, and consciously check our own emotions so that it does not affect the flow of communication. The dispute is not about you. It's about the parties being able to resolve their dispute without having to go the whole haul of going to court. Remember yesterday, I mentioned that one of the means of conflict resolution is competition. And competition emphasizes on positions. But for us in the mediation space, we are to thread the path of conflict resolution that involves collaboration, that involves compromise, so that at the end of the day, there is nothing left to be fighting over except to continue to fight for the peace and the tranquility between them. Now, important communication tips for a mediator. You need to take the initiative. And this starts from the very beginning of the mediation process. The tone of your voice, the command of your voice, how you relate to the parties is extremely important because that sets the tone. How you relate to the parties from the beginning determines how they would speak going forward. If you come in as a mediator and you're like, good morning, everyone. How are you doing? I hope we're doing well. At this mediation, sorry, parties, can you introduce yourselves? Oh, sorry, I'm not introduced myself. My name is Fuluke. My name is Fuluke Akiwaladu. Can you introduce yourself, parties? Already you've lost the parties. The parties are looking at you and wondering, is this the person that's going to help us resolve this dispute? The person doesn't even seem to have a hold of herself. So you need to be able to take the initiative from the beginning. Stamp your mark. Have the self-confidence to introduce yourself to people with style and grace before they make this first move. So we're going to do opening statements, but a general opening statement would be, good morning, ladies and gentlemen. My name is Foluke Akimoladu. I have the privilege of being your mediator at this mediation session. I'm a lawyer and an accountant, and so you can, when it has to do with finance, please feel free to bring forward any finance-related information that you think would help us to amicably resolve the dispute between you. That being said, before I go into an introduction on how the mediation process works, may I kindly know the parties who are here at this mediation. You see, at that point, I've done two major things. One, with the tone of voice, I have shown that if I need to address on civil language, I have the tone to show that I can do so. The other thing I've done is I've introduced myself as an expert such that the parties can feel free to bring forward things that they think might be complex. Now, what I've noticed, especially in mediations where there are lawyers, when you introduce yourself as a mediator who is a lawyer, it usually tends to diffuse some, let me, for the lack of a better word, say tension, because I've noticed most lawyers become more confident to railroad the mediation process when the mediator is not a lawyer. And I think that is also important for those of us that are not lawyers and who are mediators to very quickly identify that and begin to, establish your experience in the space. So if you've been a mediator for maybe over 10 years and you're a civil engineer and you have lawyers before you in a construction dispute, you immediately, say it once they begin to exhibit any form of disrespect to you. You say, I'm sorry, gentlemen, I am a civil engineer. And as far as this dispute is concerned, there's a need for an understanding of, there's a need for a deep understanding of how construction works. And so my job here may not be to tell the parties what to do, but it is easier for me as a civil engineer to help the parties to see the areas that they may not be seeing that had led to this dispute in the first place. So I would appreciate the lawyers allowing the parties to speak so as to enable us all to have a better understanding of how this dispute arose so that we can amicably resolve the dispute in the interest of all the parties here. So you can see by saying that, you have sort of put the lawyers in check. Don't be the one to hinder the progress of your client. And I think that it's very important for those of us who are mediators that are not lawyers to be very, very conscious of this. I've seen this happen too many times, and I think I need to mention that being a mediator is a calling in itself. Do not allow the parties to intimidate you, whether they are lawyers or not. I've had the privilege of mediating a matter between 4 senior advocates of Nigeria. Even though we didn't settle at the end of the day, one thing that was clear was that all parties had a better understanding of what the dispute was by the time we're done with the mediation. And truly, a mediation may not necessarily end up in settlement, but you must be able to transform the relationship of the parties. And the parties should be able to come out of the mediation saying, telling themselves, okay, I didn't realize this before. This and this is what I now have an understanding of. So smile, very important. Please smile. It's important to smile intermittently. Don't smile to the point that the parties think you're a joker, but have a welcoming enough face, especially in scenarios where you see some form of power imbalance. Then be warm and friendly. Yes, ma'am. Who is speaking, please?
Yeah, it's Salamatu, ma.
Oh, okay. Yes.
Yeah, I actually have a question and an observation as well.
Okay.
Yeah, in respect of lawyers being in attendance during mediation proceedings.
Yes.
I think it's actually important to note that, in the mediation section, it's all about the parties,
yes.
not their representatives. So at that point, lawyers are becoming like a stumbling stone to, settlement. It's now for the mediator to back their mind to the fact that where parties are present, they are not to, take over the section from the parties. And at that point, you can actually make them to know that, okay, if they are being problematic to the section, it's for us to see them. They can only be heard. They can only be cited, not be heard at that point. Because many a times, we find out that lawyers make it a little difficult for us to progress in settling. That is just my observation, ma, concerning legal practitioners.
Okay, so there are 2 sides of the coin. For me, okay, I encourage parties to bring their lawyers because, especially when it's a court-referred matter, the lawyer was the one that had put together the facts and the issues for determination. So it's always helpful to have the lawyer that put forward the claim, the defense, the reply, and all in the room. Because sometimes the party will hear for the first time that a claim was put in their processes. Most lawyers will not send the process after they have written it to the client to vet before they send it to court. And so at that point in time, I've been in mediations where parties are pleasantly surprised and say, did my lawyer put that there? I didn't know, and that can be quite revealing. But the other side of the coin is this. I completely agree with you that some lawyers, especially lawyers that don't understand how mediation can help them, tend to be a stumbling block. And I've had occasions, a number of occasions, to have to tell a lawyer, look, your being in the room is not compulsory. If you notice, I slow down when I say compulsory. So when I'm trying to talk to lawyers, I say your staying in the room is not compulsory. So I also look at the temperature in the room. If the person is the kind of lawyer that is cantankerous, I would call a private session to speak to the lawyer alone and say, Mr. B, in this mediation, your presence is not necessarily compulsory. However, I respect the fact that your client respects your advice, respects your opinion on the matter, but I would strongly appreciate it if you would allow your party to speak and to be able to speak their minds. Some lawyers have been cooperative, others that have not been cooperative. I've asked for a caucus session with their parties, and I realized that at the next sessions, the lawyer does not come and we actually get to settle. We've also had situations where you want to have a private session with the party, and then the lawyer say, no, I am the representative of my client. My client can say nothing without my authorization. I immediately tell them, this is a mediation process. And if you refuse to allow your client to speak, especially if it's a court referred, I will write in my report that it is the lawyer that was the reason why this mediation did not progress. Usually when I say that, lawyers back down, like, well, I didn't realize it was like that, but okay, you can speak. Mr. A, please go ahead and talk. I've had scenarios like that. But I've actually had a scenario where I'd had
sorry,
to...
ma.
sorry, ma, just a minute. Let me just quickly conclude. Yes.
Yes,
I've had a scenario where I told, this was a mediation where we had, I believe it was lawyers from a very big law firm, and they were using the opportunity to turn it into a discussion, or sorry, a cross-examination of the party on the other side. And I said, look, your presence here, that I said it in the open session, the joint session, your presence here is not compulsory. And please kindly do not take over the mediation process. Your presence here will help your client to be more comfortable, but please do note that I can ask for you to leave. Immediately after that, we didn't hear anything all the way to the end of the session. So it's very, very important for you as a mediator to be confident about what you're doing, which is why effective communication for a mediator is very, very important. You have to be confident in what you're doing. You have to understand the powers that you have as a mediator, especially under the Arbitration and Mediation Act. And I strongly encourage us in the development of our mediation career to take that piece of beautiful legislation. It's under Part 2 of the Arbitration and Mediation Act, all the way from sections 66 all the way to 92. Please go through it, both the mediation section and the miscellaneous section, to understand the powers that you have as a mediator, so that you can speak with confidence when you come into these mediations. Yes, Madam Eunice.
Yes, ma. On that note, I wanted to...
Is it just me or I can't hear her? So can you come again, ma? I think I lost your communication, your network with it.
Okay, ma. I wanted to know whether as a mediator, you can call the lawyers not in the open session to before the commencement of the mediation, whether you can call the lawyers secretly to address them.
Yes, you can have a private session. Yes, you can have a private session with the lawyers. So I recently handled a mediation where there were about 6 lawyers, 5 or 6 lawyers. No, there were 6 lawyers and multiple parties. And it had to do with land, it had to do with title, it had to do with bank loans, third-party mortgages, and the likes. So what I did was I called the lawyers together. And it was an online session. So I asked for a caucus session with the lawyers, essentially asking the lawyers to help in creating a conflict roadmap for having to resolve the dispute, because it was rather complex. There was a bank involved, there was contractors involved, there were people who had done work for the Lagos state government involved. Then there was a family whose land had been tied up in all of these activities. And so one of the things I mentioned to the lawyers is, look, this is a mediation process. You can choose to go back to court because there are a number of legal issues that needs to be ironed out, even if we sign up to a mediation agreement at this point. And so a number of the lawyers agreed with me, but one of the lawyers said, as much as he agrees with me that there are legal issues to be addressed, the point is that there is, they would spend years in court just trying to get those legal questions answered. And so it is best for them to have a roadmap for negotiation through this mediation, such that even if they leave the mediation to go back to court, certain things would have already been settled that they can use as consent judgment. And then the other things that are left that requires a declaration of the court can then be left as a declaration of the court. But the important core things that have to do with the land and has to do with the monies involved, which was, I think, almost 300 million, is easier to iron out because the negotiations and the mediation would have addressed those issues. So that was what we eventually did. On the issues that had to do with money and land and title, the parties agreed to exchange documents that will help with their negotiation. And in so doing, they were able to iron out certain issues. So again, in that particular scenario, even though they didn't technically agree at the mediation, they were able to use the things that they had agreed to and taking that to and use that to continue with the court case. And the good thing about such an outcome is that the court matter would take far less time because there are less issues to determine. Parties had already sort of had a partial agreement based on the advice of their lawyers. So it's always good to have the lawyers on board. It's always good to have the lawyers aid you in the mediation process. And there are actually trainings called mediation advocacy, which I would encourage us all to do at the earliest convenience for those of us who want to be either mediation representatives who are lawyers or as lawyers who want to represent our clients in mediation. It's important that the lawyers are seen to be helping the mediation process. And as the mediator, it is your responsibility to bring the lawyers on board so that they are helping you and not working against the progress of the mediation process. So smile, be warm and friendly in your introduction. So we'll just move on to the next one. Then remember people's names and use their names during conversations. So in your opening statements, it's important to ask the claimants, please, how would you like me to address you? Some might, on their processes, their name might be Chief A, B, C, and D, but they say, no, just call me Mr. A, B, C, and D. For some, they will tell you, please call me by my full name. My name is Chief Professor Dr. Engineer A, B, C, and D. And that's exactly how you call them. Oh, sorry, Chief Professor Dr. Engineer A, B, C, and D. What do you have to say about this? Don't make fun of it because to you it sounds ridiculous. To him, he knows the number of years he took before he got those titles. And if he chooses to be addressed by those titles, please, by all means, address him or her by those titles. There are some, I've seen this happen where you have senior ladies who are not married, and they'll tell you, please address me by my miss. So don't mistakenly say Mrs. just because she happens to be an older woman. So you need to be sensitive about these things. Remember their names and use their names during conversations. Remember to ask how they would like to be addressed. Then mind your voice. Your tonation is very important. How you address people is extremely important. And I remember a mediation that I recently was recently involved in had a first-class chief, and despite the fact that it involved his company and all that, I tried as much as possible to be as respectful as I could be, without necessarily compromising the office of the mediator. And how do I mean? Have a higher level of deference, but do not be apologetic. In other words, don't communicate with a party just because of their title or their position in such a way that the other party thinks that you're already biased against them. But respect them in such a way that the other party will know, the mediator as a person, because he's a Yoruba first-class chief, the mediator of a person who is a Yoruba woman, showed by the way she related to the chief that she understands the sacredness or the seriousness or the hierarchy of his office. Now, again, you need to be careful, balance it in such a way that the other party does not think that you are trying to be biased against them. And interestingly, the other party were very respectful to him as well. So it wasn't an issue of I was doing this against the interest of, you know, the other party. Mind your voice. Don't speak so quietly that people can't hear you. Use intonation and variety in your voice. So, like I mentioned, when I spoke to when I spoke to when I speak to lawyers generally, I try and lower my voice almost to a point that it's only them and not their clients that can hear what I'm saying. Or just call it private session, like learned counsel. This is not it's not compulsory that you are in this mediation session. I've seen some very interesting younger lawyers become very animated at the mediation session. And I said, well, Mr. A, B, C, and D, I'm a lawyer like yourself, and I know some of the things that you are. I know some of the things that you are trying to highlight. These are things that is best highlighted and best addressed in court. Some will say, well, you know, I've been in litigation for a long time, and this and that. I'm like, counsel, I'm 20 years post-poll. I know what I'm saying. These are not issues we can address at mediation. And usually when you tell them that and they know your years of follow, they know that you obviously do litigation, they begin to pipe down. So it is important for you as a mediator to stamp your authority on the mediation process. Don't allow anybody who hoodwink you or will rail you into feeling inferior or feeling inadequate. And if you feel that there is intimidation, if you cannot continue, you either recuse yourself or you get a co-mediator who is a senior lawyer. And so I've seen in some banking mediations, I've seen where mediators have asked to be added, you know, to have asked very senior lawyers who maybe were working in the banking industry for decades to come and co-mediate with them, so that the next time the lawyers come in with all their paraphernalia, the co-mediator can respond and say, no, this and this is the way this is going. It's not as if we don't know the options that are open to the parties in court. But here in mediation, we're trying to look at how to move this process forward. And we would appreciate it if you refrain from having to continuously refer to legal matters which you know can only be addressed in court. So there's a lot of psychology in this, but what is important for the mediator is stand your ground. Don't let anybody hoodwink you or rail you into thinking that because you are a mediator, you are in a way lower in standard or in capacity or ability to the lawyers in the room. It's not a competition. We're all in this together to help the parties to amicably resolve their disputes. It's not a sparring competition. It's not a competition to show which dispute resolution practitioner is more effective in the matter. So at this point, I want to ask, do we have any questions?
Yes, I do.
Yes, please.
My question is, You said you should allow them to talk. As active listening, is it really important? This thing is sometimes when you give people the chance, they talk and talk. So how do you come in? If you realize they are just going on and on and on because they are being emotional, how do you come in to curtail the whole thing without being rude?
Okay, so first and foremost, you can immediately sound rude when you shout. So the first thing is, watch your tone of voice. The second thing is that active listening does not mean you don't talk at all. Active listening involves feedback. Otherwise, you are not able to tell the other person that you are actually listening. So, for instance, if the credit officer of the bank says that the loan entered into default in February, but the default rate started was being charged. It started accruing from April because we're giving the customer time to regularize before we then commence the default fees payment on it. Because once default fees enters, the client is, or the customer is going to be paying for both interest on the principal and the default fee combination and interest on that. As a mediator, if the credit officer is, or the recovery officer, who is usually the case, is too fast, you might begin to think, do you mean that the person is now paying for things that they shouldn't be paying for? That wasn't what they said. But and in order to ensure that you understood what the recovery officer was saying, you will ask, please, sir, can you go over it again? And please go over it slowly so that for us who are not necessarily in the banking sector, we can understand what you are saying properly. So first you said the loan ended at was supposed to have been fully paid up by so date. Please, what date is that, sir? You note that. You also say that the default started at so date. Is that correct, sir? You also write that down. You then say the default fees, you said it started at another date, or was it the same date that the default had happened that the default fees started? Said, oh no, we gave them a moratorium to allow them to regularize. Okay, sir. At what point in time was that? So in so doing, you're able to ensure that the person who is speaking to you knows that you are listening to them. So active listening does not necessarily mean that you are that you're just listening and not saying anything, if you understand what I mean. I don't know if I answered that question.
Yes, you did, but how do I even put it? It's like
Okay.
when tensions have risen, and
Yes.
then I know that you said you can give them like 5 minutes break or something, but there are
Yes.
people who naturally tend to like to talk.
Antagonistic.
But
Yeah.
when you tell them to express themselves, it's like they don't know when to stop. And you there,
Yes.
the teacher doesn't want to sound rude.
Yeah. Okay, so like I mentioned before, you are, as the mediator, you are in charge of the process. And so the first thing you do is look eye to eye to the person and look very seriously. Please, madam, can we kindly have your opinion on A, B, C, and D only? We don't want to stop you from having to say all that is on your mind, but it is important that we address only the issues before us so that we are not derailed from the process. Now, what you've done is essentially told her, if you speak your mind and you continue speaking without caution, you would help us to derail the process. So what you've done is made the person consciously aware in the presence of everybody that if they don't mind or if they are not more conscious of what they are saying and how they are saying it and how long they are saying it, they could essentially be seen as as the person who is derailing the process. So you need to be able to show consequences. Just like I spoke to the lawyers, I said, it's not compulsory for you to be in the room. The counsels that came from the big law firm that had essentially tried to turn the mediation into a cross-examination situation, that you don't have to be in this mediation. And please note that if this mediation ends at this point, I will write in my report to the court that it's counsels to the claimants that did not allow for this mediation process to go ahead. And you see, by showing parties that there's a consequence to what they say, how they say it, and how long they say it, you're able to sort of nudge them in the direction that you want them to go. Now, it also depends on the tonation of your voice. If you are shouting at them, obviously, they won't even want to listen to you. But you need to say it in a way that helps the parties to be conscious of what they're saying. Sarah Knox says, can we create ground rules before the session? Certainly. And you'll be doing that during the opening statement sessions when the facilitator is handling that. And one of the ground rules is, even though a dispute came between you, that's you're telling the parties, you must be conscious of the fact that we shouldn't use uncivil language to each other. And in so doing, you are going to be helping us in this mediation to come to an amicable settlement of the dispute. Now, in telling the parties from the beginning, let us try to use civil language or try not to be uncivil to one another despite the dispute. It's easy for you during the session to now say, do we remember what I said at the beginning of the session? That even though it's a dispute that has brought us here, please let us try as much as possible to be courteous in the words that we use so that we don't derail the process with any words that is uncivil. Now, in a situation, yes, I get this question about when it's not court referred. When it is not court referred, you essentially tell the parties that in your report on the mediation, you're going to have to put that there. And so it is now up to the parties to decide whether they're going to take that matter up in court and then use that as part of their evidence, witness evidence, that even when we were trying to resolve the dispute amicably, the counsel to the claimants was the one that hindered the process. Now, under the AMA 2023, the mediator or the parties cannot use documents that were retrieved during a mediation process. They cannot use that to against any of the other parties in a subsequent judicial or arbitral proceedings. And so it is also important that even in the non-court referred mediations, the mediator understands the powers that they have under the Arbitration and Mediation Act. In fact, that act has really empowered and emboldened mediators to be able to do things, because before, the argument lawyers had was, look, mediation is not enforceable. And they use that as a basis to essentially threaten the process and threaten the mediators in the way they can handle their mediation. But now we've been emboldened by the provisions of the Arbitration and Mediation Act. And you can tell the counsel that, look, this agreement is enforceable in court directly as a contract, is directly enforceable as a consent judgment, is also directly enforceable as a consent award. And so it is important that you are not the one seen as the one derailing the mediation process. So despite the fact that not all mediations happen in court, you can still stand your ground based on the new legal framework that we have to say, counsel, please help to allow this process go ahead, because whatever the outcome of this process is, it can be enforced in court as a contract, as a consent judgment, or as a consent award. The other thing to do to sort of diffuse the energies that the lawyer may be creating, or the negative vibes that the lawyer may be creating, is to have a caucus session with his client and say, tell the client, look, we appreciate your presence. We appreciate your lawyer's presence, but we want to understand how far you want to go with resolving this dispute via agreement. If you are of the position that you are not really interested in settlement, then we can call this mediation off to a close. But if you are really interested in us settling, please have a discussion with your lawyer so that your lawyer can help you, help everybody to amicably resolve. One thing that you must be conscious about as a mediator is not to pitch the lawyer against his client. That's not your job. Your job is to help the client to get the lawyer become cooperative in the mediation. I've had mediations where the counsel of their own volition, sorry, the party of their own volition did not bother bringing their lawyer again when they realized that, look, this lawyer is going to derail the process for me. I really want this thing to settle. I don't want to have to keep going to court. In fact, I've had a mediation session where a party said, this my lawyer is just interested in his appearance fees. That's why he's just not allowing us to move forward. And he said it in the open joint session. Of course, by the next session, the lawyer was not there. So it really depends on how you manage communication during the mediation session. So let's talk about the differences between verbal and non-verbal communication. So non-verbal, eye contact, focusing on the other person. We're not saying stare at the person, but at least look them in the eye long enough for them to know that you're listening to them. Then leaning forward or nodding. You know, when you move back and forth slowly, it shows that you're paying attention. Then sitting still sometimes can tell the person, especially if the person is jittery. If, for instance, in an employer-employee mediation, you can see that the employee is jittery. You sitting down and sitting still helps the employee who is technically the weaker party to feel like, oh, I can confidently speak to this person. But if as the person is jittery, you two are also, hey, I'm wondering, will you be able to settle this matter now? The way this person is moving up and down, you know, and they can tell that that is what you are saying. And, you know, you are going back and forth, you are rocking, you are looking up, you are rolling your eyes and all. Immediately, the person will lose confidence in the process. So your nonverbal communication as a mediator is important because that helps to handle the tempo of the process. And you are the captain of the ship. You have to ensure that the ship stays afloat till it gets till it's docked at the port of settlement. You know, to put it mildly. Then letting the other person finish what he or she is saying without interruption. So like I mentioned, interruptions are things that would adversely affect the communication, the ease of communication between the parties. Then interested silence, giving the person time to respond. If the party feels like you are always having to jump in before they respond, they will feel like their opinion is not important to you. And so they'll keep quiet. Remember, as the mediator, you are not a party to the dispute. So do not aggravate the dispute by giving your opinions on it, except it is asked, unless it is asked for. So let us be conscious of this. Let us be aware of this. Now, for verbal communication, especially listening, active listening, restating what someone says helps you to know whether or not you got what they were saying. So this is again part of active listening, again part of communication. Then reflecting on what someone is feeling. Remember, I said identify the emotions in the room. Identify when somebody is bitter. Identify when somebody is pained. Sometimes you might have to do a caucus session with that person who is pained to find out what is your real pain. I remember a mediation that I handled where the man just kept saying how bitter he was about the fact that his wife kept insisting about a particular school for the child, for their child. And, you know, it was a young marriage, young couple. The child was less than 2 years. And like, why would I put a child in a school that is paying almost 300,000 when my monthly salary is 150,000? And, you know, he said, on top of that, I'm still going to pay maintenance. I'm still going to pay for having to maintain his health, maintain the child's health, that's health insurance and things like that. So he was very bitter, not just because the wife was insisting on this school that he obviously couldn't afford, but more importantly, because he couldn't understand why she was not being considerate. And it was in the comfort session he said that. He didn't say it in the joint session. In the joint session, he just kept saying, I can't afford it, I can't afford it. But in the private session was where he said, look, I'm very pained that the welfare of this child is not as important to this woman as the money she can get from me. You know, so it's important to identify the emotions in the room. Then I see a question here. How do you handle a situation where threat is involved, especially in a situation where they were referred by court? So in the mediation report, if it's a court referred, then it means it is in a it's probably under a multi-door courthouse system. You write a mediator's report to the multi-door, stating that there is threat to life and that you would like to have police involved. So we've had situations and scenarios in the LMDC where the LMDC has called for the police to investigate the possibility of a criminal activity with respect to threat to life, especially in marital issues. So yes, it's very possible to make a report in that regard. Okay, so let's quickly move on. So non-verbal methods of communication, effective speaking, effective communication, and examples. I won't talk about examples now. I will leave that to the end so that we'll all be involved in it, so I can finish the content. Please, can we mute if we're not speaking? Okay, so close-ended questions. We're talking about questions now. Close-ended are designed to elicit short, precise responses that are ideal for fact-finding and narrowing down options. Then we have open-ended. You want more details, so you have open-ended questions. Probing, you want to understand why something is what it is, and it's often used in research and interviews. Reflective is introspective in nature. Reflective questions prompt self-analysis and personal growth. Leading questions are questions that subtly influence the direction of discussions by influencing and helping to shape responses through words used in the question. Salamatu, do you have a question?
Yes,
Salama,
yes, ma.
Yes.
Yes, ma. I have a question. In respect of caucusing, you have a private sections with parties. Yes. What do you do with information they got from each? Do you divulge it during the joint section, or you try to, settle the parties with the separate information or details that you got from parties separately?
No, come again. You're talking about the private sessions.
Yes, that's caucusing, where you meet parties separately.
Yes.
What do you do with the information or the details that you get from parties separately?
During that private session. Okay, so what you do is that you ask the parties, how much of this information do you want me to repeat to the other party? So there are two possibilities after that private session. It's either you leave that private session and have another private session with the other parties, or you call the parties into a joint session. But it's always important, if you have a private session with the claimants, you must have a private session with the defendants with the same amount of time. So it's possible you get into the private session and the defendant says, I don't really have much to say. Now, in that scenario, of course, you know that you've done your duty as a mediator to ensure fair hearing and equal opportunity to speak their minds on the issue. And so when you are in the private session, you ask the party who you are speaking to, how much of this information do you want me to tell the other party? So they call it a shuttle diplomacy. The party will then say, okay, out of 1 to 5 that I've said to you, only talk about 1 to 2. 3 to 5, I would decide based on what they say, whether I want to devolve that that information. So it is for you as the mediator to be conscious of the information you give and the information that you don't give. And so it's usually best to summarize that in points, just so that you don't forget and don't mistakenly say something that the party didn't want to be said in the other part, to the other party to be said, either during private session or during caucus. Because what will happen, or during the joint session. Because what will happen is, if, for instance, during the joint session, you go and say something the party says don't say, the party will then become, apart from having a sense of betrayal, the party will be closed up. They won't want to say or open their minds in going forward. And you don't want to get to that point. That is what we call a mediation impasse. You don't want to get to that point. So quickly on questioning, closed-ended. A closed-ended question could be, what is your name? In most parts of the world, is a closed-ended question. In Nigeria, it could be open-ended. My name is Mr. ABC and D. I am the son of ABC and D. I come from the tribe of ABC and D. But on a general basis, what is your name is generally a closed-ended question. Or what is the address of your house is a closed-ended question. You can only be living in one place. An open-ended question could be, what are the types of movies you like to watch? That is open. I like to watch action films. I like to watch drama. I like to watch romance films and all that. Then probing seeks comprehensive insights and often used for research and interviews. Before I go on, Jerry's asking a question. Is it possible for a clergyman to apply mediation methods during counseling? Absolutely. In fact, the mediation skills training helps you to become a better counselor, because you understand effective communication better. You understand that you can take yourself out of the dispute. Counselors try to help parties to the point that you almost feel like you are trying to protect them from what can hurt them. For mediation, it is not about protecting. It's about you having to answer your questions yourself. And so for parties to be more cooperative in a counseling session, it actually helps the mediator it actually helps the counselor if the counselor has mediation skills. So I'll just quickly go on to probing. How many students in the class registered for this course? That is a probing question, because you can't answer that question without having to do some form of research or interview some of the students. How many of you guys signed for this course? Then reflective. This is introspective in nature, is reflective questions that prompt self-analysis and personal growth. So a question like, what do you see yourself become in 10 years' time? And this might be a question you might want to put to a child in a custody issue, if the child is going to be called into the mediation. You might want to ask that so as to get whether or not that particular child wants to remain with a particular parent. So if a child says, I want to be able to live for America, and it's the mom that is currently residing in America who has come to Nigeria, you can then get from that kind of question that that child would prefer to stay with the mother. Then leading questions. Leading questions, for those of us that are lawyers, we did leading questioning in the laws of evidence, and that is to guide someone into the direction of the particular answer you're looking for. And so you ask a question like, didn't the person say they were going to be at home at 4 p.m. last night? So you're essentially trying to get the person to say, yes, they were at home, because you want to get the person to say, yes, they were at home, to confirm that. And so you are leading the person to answer in a way that would reflect the answer you were looking for. Or another leading question could be, this person always wears black on Fridays, isn't it? And you want it to be seen that that person always wears black on Friday. And so leading questions help to guide in a particular direction the answers that you want. Now, for mediation, your most important tools are close-ended and open-ended questions. Probing might be a bit intrusive, but it's important to know times when you may need probing questions, the times you may need reflective questions, the time you may need leading questions. So just to give us time for the practical sessions, because I really want us to ask these questions. Close-ended questions can be answered with yes, no, or a brief statement of fact. Were you at the party last night? No or yes. So a close-ended question, do you like reading fiction novels? This is a closed question because the other person will probably say yes or no. Open-ended question, what kind of books do you like to read? This is an open question because the other person could respond in many different ways. Then ask different open-ended questions, open and closed, and analyze them. How can open and closed-ended questions aid or stall communication? Before I give this to us to answer, I'll quickly talk about mediation impulses so that the exercise session will be just at the end of all the presentation I have to make. Some factors can cause frustration for parties, which can often take mediators by surprise. Things like environment, values, religion, education, and learning. This informs the meaning of the communication that parties make at a session. And so it is important for a mediator to have a brief understanding of the parties involved. Every mediation or negotiation has a unique character, influenced by the cultural perspective of the parties. So I know for some arbitral institutions, or sorry, for some ADR institutions, if you have the red cap chiefs or from the Igbo side of Nigeria, you would not appoint a young Yoruba or Hausa female mediator to mediate the matter because of the possible lack of understanding of the cultural nuances that brings to bear where such gentlemen are involved in the mediation. So it's also important as a mediator, be sensitive about the cultural backgrounds of the parties that you are relating with, especially if you are dealing with land, custody, or family matters, customs or family matters. Different perspectives may impede the process of resolution and agreement if the parties agree on fundamental issues. So again, those are some of the things that we need to be cautious about. Then when issues based on individual rights or strong group identification arise in a mediation, a mediator's awareness can help surmount such cultural barriers. So as a mediator, your understanding of the cultural nuances at the background or the cultural backgrounds of the parties can help them to better understand how to resolve their disputes. So now, close-ended questions. I'm going to, so Moyosore Olaoluwa, I'm pairing you up with Audu Thomas. Now you're going to ask a close-ended question, and Audu Thomas is going to tell us whether he or she feels that is a closed or an open-ended question. So Moyosore, the floor is yours.
Sorry, can I get like an example of a close-ended question I could use in this context?
There's that. Do you like reading fiction novels? The example is already there. So it's for you to ask another question. And Audu Thomas will answer whether it's a closed or an open-ended question.
All right. Mr. Audu Thomas, do you like eating eba for breakfast?
Yeah, that's a close-ended question because I'll say yes.
Oh, okay. Sorry, ma, I didn't realize it was you. Okay. You're using two devices.
No, I didn't get on one. I just renamed my device.
Oh, I see. Okay, okay. So the answer?
It's a close-ended question.
Okay. Thank you very much.
Thank you.
Yes. Josh Zaka, kindly ask an open-ended question, and Augustine Chima will let us know whether or not it's an open or closed-ended question. Josh Zaka. See, this is how we know those of us that are in class.
Sorry, you won't believe it. I'm actually where I am. There's also an interview taking place. So
Okay. So I'll just call on someone else then.
sorry.
No problems. So Jerry Mogaji, kindly ask your open-ended question, and I believe it's who is the other person now? Okay, let me just change the other person to Ayubadana. Stefan, please let us know if the person is asking is a correct open question.
Okay, ma.
So Jerry
Am I the one
Mogaji. Okay, you can go ahead and ask the question while Jerry Mogaji will let us know whether or not it's an open question.
Okay. Mr. Jerry Magaji, did you sleep well last night?
Mr. Jerry?
Please. Hello.
Yes.
Can I get your question? Can I get your question again, please?
Okay. Did you sleep well last night?
Yeah, this is an open, close question. Yes, I do, or I did.
You have to pick one. You have to pick one, sir. You have to. Is
Yes,
it that
I
is open or closed? Is it an open question or a closed question, sir?
It's an open.
Okay,
No,
why
I
do you say so?
I disagree.
I think it's a closed question.
Yeah, I think it's a closed-ended question as well.
Okay.
Um.
Maybe I did not get him well.
Oh, okay. Can you? I think that was Josh Zaka, right?
No, it's Ayubadana Steven.
Ayuba, sorry. Kindly rephrase
Yeah.
that question such that it will be a open-ended question. Because the question you
Okay.
asked was actually closed-ended.
Okay. Okay, let me rephrase it to be open-ended.
Yes, please.
Okay. Mr. Jerry Magaji, how was your night?
No, that question has been asked before and it's a closed-ended question, sort of.
Okay. Can you explain how to cook rice?
Yeah, this is an open question.
Very good.
I think it's a leading question.
How is it leading? And what is it leading to?
Lawyer speaking.
Why would the question be leading? Oh, sorry, can you kindly let us know? Because we're all learning from each other. Why do you think the question will be leading? Explain how to cook rice.
Because the person asking the question, he's seeking for ways, or let me say, an explanation.
Yes.
On how to cook rice. So it's
yes,
more
but
of a leading.
It's actually an open question because you're going to be giving a lot of details.
Yes.
It would be leading in the circumstances if the question in issue was whether or not rice was consumed by somebody that was used to poison him. So if they now ask the question, how do you cook rice? It would then be a leading question because you are leading the person to first admit that rice was involved in the crime and that rice might possibly have been cooked by that person. So in that particular context, yes, it will be a leading question. But in this context where we're generally asking questions, it's actually an open-ended question. Okay, so yeah, we'll just do another 5 minutes so that I do not take too much time of the next facilitator. So Miriam or Shiri, kindly ask a closed-ended question, and Helen Amuchi Olga, let us know if it is a closed or open-ended question. So Miriam, you have to ask a closed-ended question. Let us be quick, please. Miriam, kindly unmute. Yes, thank you.
Okay, good day, everyone.
Good day.
Is that Helen I'm being paired with?
Yes.
Helen, how are you joining this meeting?
How am I joining this meeting?
I mean, are you joining? I'm just assuming that we have this session both virtually. Asking how you are joining the meeting.
I don't think that's an. Wait, are you asking an open-ended question or a closed-ended question?
That is for you to answer.
What kind of question were you asked to ask?
Sorry?
Okay. I think this is an open-ended question. It gives room for me to give details. I think it's an open-ended question because it requires me to give details on how I went about joining in, as to my network, the device I'm using, and all of that. So I think it's an open-ended question.
Okay, Miriam,
what I mean by the question, yes,
exactly.
What I mean by that question is to know, because I'm assuming, I'm just trying to imagine on site. So when I'm asking how you're joining the meeting, I'm trying to if you'll be attending the meeting physically. So I think it's a closed-ended question, but maybe the way I framed it.
From the face value of the question you just presented to me, how am I joining this meeting? I think from what we understood from communication, what I got as your meaning was by what means. And like I said, it requires a lot of details. So I think it's an open-ended question.
Okay, so let me come into this. Let's not have a debate over it. I think that it's open-ended in the sense that there are multiple options of answers to give. So, but Miriam, I understand what you mean in terms of it can be closed because there should only be really one way of answering that question, which is I joined via Zoom. But this also goes to show how what may have been intended to be a closed-ended question can end up being an open-ended question, and you begin to have information that you may not necessarily need in that particular mediation. So it's good that this came out, and it helped me to be able to emphasize that point. And so, Miriam, if you were going to rephrase that question such that she only has one way of answering the question, how would you rephrase it?
Basically.
Sorry?
I'll ask.
Okay, one way to ask is that, Helen, did you join the meeting via Zoom? So that automatically is it's a yes or no answer. So in that particular scenario, it's a closed-ended question. And so as I round up, I just want to say that let us be very conscious of the answer we are looking for. So even if we do not know what the exact words of the answer is going to be, let us know what the objective of the question is before we ask, because it's important to have that at the back of our minds so that people don't, or parties don't misinterpret the intention that we have, which is essentially to help the parties to amicably settle. So that being said, I want to say thank you very much for listening, and stay blessed and have a great day ahead.
Thank you, Ma. Thank you so much, Ma.
Thank you, Ma. Thank you very much.
Thank you,
so
Ma.
much.
Okay,
Yeah.
so please, at this juncture, let us
Thank you.
put on our camera. Let's have a snapshot. Put on your camera. Let's have a snapshot.
Let me flex.
Darling. Thank you. Oh, but she's making it too short. No. Yeah, better.
Put on your camera. Let's have a snapshot. May I, on behalf of the governing body of Settlement House ADR Training Institute, appreciate our first speaker for giving us that wonderful training. It has been very, very interesting. We are very, very grateful. We thank her on behalf of the management of Settlement House. I believe that the trainees really enjoyed the session and they are very, very grateful. Thank you very much. This is one of the important aspects of the training, and I believe that you have taken note. As a lawyer and as a mediator, you know, your active listening, your questioning abilities actually makes you a great mediator or arbitrator, a great mediator or an ADR practitioner. So she has taken time to explain to you and help you understand what it stands for and what it means and how to go about it. And that is a very wonderful job. We are very, very happy and grateful. The trainees will ever be grateful for you laying this wonderful foundation. How? The chairman of the governing body of Settlement House is here. Let me hand over the mic to her. I didn't know when she got in. You're welcome, Ma. May I hand over to you to especially appreciate our facilitator. She has done a great job. Day 1, day 2, day 3, she has been the foundation layer for us. So over to you, Ma. We're happy to have you, and then you'll be part of our photograph. Thank you very much. Please put on your camera, all of you.
Super.
I want to see your beautiful faces.
Okay. Good morning, everyone.
Good morning, Ma.
It's my pleasure to join this session today. I couldn't join yesterday because of my very, very tight schedule. Like I told you from the beginning.
You're welcome, Ma.
Thank you very much. Thank you. Thank you.
Granny, good morning, ma'am. Good to see you
Good
today.
morning. Good morning, everybody. Foluke has done wonderfully well. Well, I told you that you're privileged to have her teach us some of this nitty-gritties of ADR. I said she's an international expert. So I'm sure from the beginning, some might say, well, let's see. I'm sure that you have seen, and I'm sure that you have witnessed, you have handled it. And I believe that after this training, your negotiation skills, your mediation skills, your arbitration skills, your ADR skills, by virtue of your class this morning of active listening, you're going to practice clients, and even those that are the clergy, or advising or encountering, we'll be very happy to have very delicate aspect of ADR. It's be able to settle down to listen to parties out if you're patient. And so they will do a lot of things to ensure that they irritate you. But if you follow whatever they are saying. Thank you very much for looking. Thank you. I've also learned, and I wish you all the best in your endeavor. For the participants, I want to
Thank you,
congratulate
ma'am.
you once
Grateful.
again that you're very seasoned ADR experts taking you on these courses. So please stay tuned, especially those of us that are working today. It's a public holiday. Don't miss any of today's classes. And stay blessed.
Thank you,
ma'am. Thank you, ma'am.
Thank you very much for that wonderful session. We're happy to have you take that session. Thank you for the chairman of the governing body who have appreciated our speaker. Today we are going to be going to the next important aspect of our training. We are going to be having some adjustments to the class, to our timetable. We have learned mediation skills. We have learned some of the techniques that we need to become active and professional mediators. So what we are going to do now, we are going to go into the practicals. And we are going to go into practical after this session. So, and then we are going to use the first simulation we have on our timetable to do that. We have taken the photograph. Thank you very much. We would like to be seeing your faces like this. I am going to be taking this class, and let's see how far we can go. As I said, my name is Nanchang Nangwang. I am the Executive Director of Settlement House India Training Institute. And I have the singular honor and the privilege, with the kind permission of the chairman of the governing body of this Settlement House India Training Institute, to take you on negotiation skills. I wish she was not here because she will put me on that tension. But thank God her camera is off. So we are going to be looking at negotiation skills. And negotiation is one important aspect of the whole mediation. In fact, we said that negotiation is actually an assisted negotiation. While negotiation takes place between the parties involved, negotiation is usually takes place just between the parties, while a mediation session is one that takes place with the assistance of a third party. So without wasting much time, I I appreciate the privilege of speaking to these distinguished participants, and I'm happy that you made this possible. For a brief introduction, I don't know if my profile has been sent to you, but I am a dispute resolution specialist. I practice as a lawyer, as a mediator, as an arbitrator, a negotiator, a mediation advocate. I practice in all spheres and aspects of ADR. I am a certified teacher, and I'm an attorney mediator. I'm a faculty member of Settlement House ADR Training Institute. I am also a faculty member of Nigerian Institute of Chartered Arbitrators. I am married to a female wife, and I'm blessed with 2 children.
That's wonderful, female wife.
Yes.
Have male wives these days.
Yes, it has to be very clear. So, by God's grace, I will be taking you on negotiation skills. Negotiation skills cannot be under, how do I put it? It's a skill that we cannot overemphasize. Everything we do from day to day is based on negotiation. So we are hoping that in the course of this training, we are going to examine the process and tools for effective negotiation. And our learning outcome for you is we are hoping that at the end of the training, you should be able to understand what negotiation means and the various skills that you need in order to become an effective negotiator. And we expect that the participants, you should be able to demonstrate the practical skills that is needed in negotiation. And then we also expect that you will be able to understand the stages involved in negotiation and what to do at every point in time. Please, if I'm too fast, you let me know so that I will. So by way of introduction, you know, negotiation is something that we do on a daily basis. If you are married, you must have negotiated this morning. If you are not married, but you have a girlfriend, which we do not encourage anyway, you must have negotiated this morning, one way or the other. If you are coming to work or you are going somewhere in order to attend this training, you know, and if you are driving, you must have negotiated because you may be about to enter the road, and then you discover that somebody is about to enter the road as well, and then sometimes you have to match brake to allow the person to pass. That's a form of negotiation. It's a give and take. And where you see negotiation fails, you don't need anybody to tell you the effect of of that. You know, if you are in a car and then instead of matching brake, you refuse to match brake, and the other person too refuse to match brake, so negotiation has failed. And if negotiation has failed, definitely you know the effect of a failed negotiation will be very evident. That is what is called accident, and then you will see it. But if you are bargained with a bike man or a bus driver today, tell you the transport fare is 500 naira, you say, oh, is it not just here? I will give you 5 naira. You say, which country you be? Say, I beg, come up for here. You say, no be business you do. Why they get angry like this? You know, you are negotiating everything you do about life. Sometimes you want to sit down, somebody sat down and is balanced, and you say, please, can you shift for me? Say, no, you know, the place is tight. What are you doing? You are negotiating. Say, okay, let's manage. The person will shift for you. That's negotiation. If you are following me, can you give me a thumbs up?
Follow.
All right. So we have established in the course of our discussion in negotiation technique, in understanding conflicts and conflict analysis, that because of our relationship one way or the other, we have established relationships, and because of that relationship, conflicts are bound to occur, bound to happen, and they happen because we are human, and our ability to resolve those conflicts is what makes us better human beings. So when you are married, you know, one way or the other, you have conflict with your spouse. And if you are not married, you're working in an office, one way or the other, you have conflict. But I learned that people who have conflict and resolve the conflict end up having a better relationship compared to those who say they never had any conflict, or they cannot have conflict. If you agree with me, I will need you to go to the chat box, the chat room, type yes, I agree, yes, I disagree, and let me know your opinion about that. Having said so, the essence of negotiation is that people want to get a fair outcome that is acceptable to both of them. So I want something, you want something, but there is a way and manner you should go about it so that you will not, you know, like somebody, you want to acquire a property that you need so important and you have the resources and the money, you just go. Or you want to marry, don't mind me. Let me, I'm using husband and wife and all of those kind of things. Let's say you see a woman you want to marry, and then she's so beautiful, but she's coming from a poor background. And then you came with your big jeep to the house and you looked at her and said, wow, you are beautiful. I want to help your life by marrying you. Let me change your story forever. You know, let me also use the opportunity to help your wretched family, your wretched father and mother, you know. By the time you finish saying this thing, even though she may be interested in the money, she may decide to say, oh, she's not interested because you are not seeing her as someone you value a lot. Mr. Ephraim, are you saying something? No. Okay. So, if you are with me, can you give me a thumbs up? If you are with me, can you give me a thumbs up? I want to see your faces. Oh, great. I can see Cordina. I can see Glory. I can see Dachom. They are the only people that are following now.
No, we are here, sir.
Oh, you give me a thumbs up. I will know that you are with me. Right? Aha. So, as I was saying, when you see a house, a property you want to use and it's in a strategic location and you go and say, oh, you know, how are you doing? You say, fine, I'm here to buy you and the property. Any amount you want, just name it. Do you think you are going to succeed in purchasing that property?
No, sir.
Who is answering?
No.
Salamatu.
Salamatu.
Put on your video and tell me why you will not succeed.
Yes.
Will you succeed?
Because you are coming. No, not at all. You are coming up with in a very purposeful way, or boastful way, so to put.
Okay, so is it because it is boastful that you are not going to succeed?
Manner of negotiation wasn't right.
Okay. Why?
The manner of negotiation.
What makes
Hello,
it
sir.
not, what makes it not right?
Hello, sir. Money cannot buy everything.
Okay.
Said money cannot buy everything.
Okay. I have the money, you have the property, I can buy you on the property. You know?
Impossible, sir.
Okay. So you see, that's why we said negotiation is very important. And then when they say, okay, you can go and negotiate, but the highest you can go is 10 naira. And then you just go there and say, you know, we're interested in this property. We want to buy it. And then we don't want to waste time here. Let us just tell you this, what we are ready to do. We are going to offer you 10 naira. Final. You know, that is it. Do you think that those people will accept, even if it is smaller than this is above what they were expecting?
Also,
I
money
want to
can.
hear you speak. And when you are speaking, put on your camera, let me see you.
Sorry, sir.
Yes,
Ephraim is
Mr.
speaking, sir.
Ephraim.
But money can influence decision making. If the amount is higher, I believe it can affect the negotiation process there.
Okay. Is Salama to speaking?
Yes, I'm here, please.
Okay, so what are you saying?
I'm here, sir. No, I'm not saying anything.
Okay. So you see, when someone is ready to sell his property at 15 naira, and you come to say, you see, I'm interested in this property, let's just cut the story short. I'll offer you 100 naira. You know, by the time you say that kind of thing, the person will think, say, wow, is this not an opportunity for me to, that's 50 naira addition, isn't it? But the person will say, oh, I think I can get more. So no, we cannot sell it though. And then you begin to show how desperate you are. And that is why this negotiation class is very important. How do you make proposals? How do you present your matter and your case so that you will not end up causing liability or going to spoil the show, you know, such that your company or the person sending you there will end up suffering from the effect of your inability to negotiate. Let me just give you a glimpse of how our timetable is going to be today. We'll have some adjustments on it. And that is just by the way. So you are going to have practicals after this, and you are going to use the first simulation. Just take note. Okay, so Salamatu, we have additional participants. Ensure that you pay their fees.
We're doing our assignment at the same time doing this as well.
It's true.
Okay, ensure you send their professional fees for attending the training. Okay, so now, having said so, one way or the other, whether deliberately, do you know that there are people who cause calamity, crisis, conflict deliberately? I hope you know. Do we know?
Yes. Some persons love problem a lot.
And some, it may not be deliberate. Is that correct? It's only Salamatu and Glory that is answering me. Are we together?
We are together, sir.
All right.
Together, sir.
Okay. So don't mind me. Some of us who are teachers will always want to see that everybody is moving along. So ensure that when I ask question, if I say give me a thumbs up, go to the chat room, put an emoji, give me a thumbs up like this, or on your camera, let me see that you are following. Thank you. So whether deliberately or not deliberately, one way or the other, we get involved in conflicts. And when we get involved in conflicts or disputes, you know, the essence, you want to see them resolved. Now I asked a question earlier. Who can tell me, is it true that when people are involved in a conflict or they have disputes and they're able to resolve the dispute, they end up becoming better friends and have better relationship? Or it is not true?
Yes, of course. They
Please,
end
sir,
up having.
they end up.
Okay, who is speaking?
Okay. Pardon. They end up becoming better friends because my takes would be that in negotiation and mediation, the parties are allowed to, express themselves. They have that compulsory conferences that allow each other release whatever ingredient that brought about the conflict. But in as against litigation, which they end up becoming even more enemies like forever, even if they are blood related.
Okay, thank you very much for that wonderful contribution.
Thank you,
You're
sir.
actually a wonderful person. Thank you. Thank you very much. Somebody wants to add something?
Yes, they might end up being better friends because in that process of negotiation or mediation, they tend to know each other better. Something might have led to their dispute because, okay, maybe before that dispute, I don't know that this.
Chimada is speaking.
No, this is Abdullah Iradi.
Okay, so you can do me a favor. When you are speaking, you can say, I am Nanchang, so person, then you can now go ahead to speak. Thank you.
All right. So during the negotiation or the mediation process, they tend to know each other better. So after the settlements, they know the differences, they know what this person wants and what he does not want. And by that, they tend to adjust and know how to relate to each other, which leads to their relationship even being better than how it was before the disputes arose.
Okay, so have you ever seen someone who says, since we married, we never had any dispute or conflict, or since we have been friends, we have been best of friends, no issue, no conflict? Would that be true?
That's it can't happen.
That's not
possible.
Not possible.
Introduce your name. So
this is Molikat, and it's not true.
Okay. Why do you think it's not true, ma'am?
Because most times in any relationship, you'll have differences, you have diverse opinions. So definitely you have to, like you said in your opening statement, that at every stage in our life, we always negotiate. Like before you left home this morning, you had to negotiate. And even driving to work, we all have to negotiate. So even in any relationship, whether marriage or even with friends, there are times where you have differences and you just have to resolve it because we are human. That's it.
Okay, so
I want to say something.
Okay.
And yeah, say that yeah, because at times really there are issues are actually there, but they bottle it up, they deny, living in denial.
Oh, so where we go chop out?
And then bottle. Oh my God, please, who is talking? Please, can you mute yourself?
Go ahead, please.
So, and when they bottle it up, it looks as if there is no issue. Whereas, and that one is even the worst situation because at that point.
So, are you trying to say that people who say they don't have conflict, they are just pretending? Is that what you are saying?
Exactly, it's the worst situation.
Do we agree with her?
Yes. Yes, I agree with her completely.
Yes,
who is agreeing?
Hi, Glory Zaka.
You are agreeing with your namesake?
Yes. It's not possible to live with any human being that you will not have disagreement. You must disagree to come to an agreement. But for them to say we've never quarreled, well, then they are pretending. They only bottle up their problems, and and one day it will shoot out, and it will be an escalation. So I agree with her totally.
So if you are a good Christian or a good Muslim, you know that you will not have problem with anybody.
It's not possible, sir.
Salamatu, you are just shaking your head like this. You don't agree with us.
People based on understanding. You understand them for who they are, for what they are, and all that. So at that point, you try to manage their attitude, their character, without necessarily having any problem with them. It's not like you don't have problem with them, but you tend to understand them and take them for that kind of personality that they are created with. I think that is my position, sir.
Thank you very much. So you see, one way or the other, whether intentionally or unintentionally, we always have conflict. Just a minute. Okay, sorry for that. We all agree that conflicts are bound to happen. In fact, they are inevitable. So, but the way we handle it, like Mr. Samuel will say, that we should not have this idea that conflict is a bad thing. Conflict is actually a good thing. When you don't have conflict, you may not understand somebody's idea or opinion, you know. So when somebody say, oh, you are beautiful, you need to try to find out, you know, conflict analysis. Maybe you need to understand. Don't just take things on face value. What do you understand by I'm beautiful? Maybe it is your hair that is making you beautiful, not any other thing. Or your character that is making you beautiful. So if you have that misunderstanding, when the person is saying you are beautiful and you are thinking a different thing, while the person is having a different thing in his mind, you know, that alone is also a conflict. It's not intended, but it happens, right? So the way we see things, the way we view things, you know, can be a source of conflict. So we should take note of that. When these things happen, it helps us to look at issues, understand the foundation, the things that are fueling these things. There cannot be smoke without a fire. But you know, this negotiation is something that you needed to use. You use it in your relationship, at home, in your business, in school, in everything that you do. And if you want to operate in a professional space, you also have all these things. Having said so, if you are going to go into negotiation, there are 5 stages you need to look at. Number 1, you look at the preparation stage, proposal stage, your debate stage, your bargaining stage, and your closing stage. Now, when you are looking at the first preparation stage, you know that anything you do not prepare for, let's say you're writing an exams, if you do not prepare for the exams, definitely you are prepared to fail or you are prepared to cheat. That's why you see students, instead of concentrating to write exams, you know, they are entering with some books, either lack of confidence or they have not read or prepared, or that they have gone praying and praying to God instead of reading their book. Is prayer not good? No, prayer is good. But when you pray, you also read your books. You are going to pray as though God does not exist, and then you also you pray as though it is all that matters. isn't it? And then you read your book as though everything depends on it. Then God cannot help you remember. So, but if you don't prepare for exams, you did not do everything, you just went praying. Okay, maybe miracle can happen. You enter the exam and say, God, please, bring the answer to number 1. I want to answer 3 questions. Just write the answer for me on the board. Let me be the only one seeing it. You know, all of those kind of things. No, prepare. God will help you. You know, God will help you, but do your own part. Do your own part. So when you are going for a negotiation, you need to prepare. And in preparation, what do you need to do? You need to identify and clarify your objective. I'll give you an example. You have a mask, you need to mask on a particular land, and you discover that this land is very strategic for you. So, and you want to get that land from the owner, and that owner may be using it for something less than what you would have want to use it for, but you want to see how you can get it. So you need to identify your objective. What do you intend to achieve? What do you want to get? You have to clearly identify it. In pursuing your objective, are there areas that you cannot go into? Are there limitations? You need to identify it in your preparation. Then you need to find out information about that particular thing you are going for, the land you want to buy. You need to find out information about the area, the owner, right? Ask about what is his behavior, what is his like, what is his dislikes, you know, how is the business flourishing, you know, what he's doing there, is it okay, you know, how much is he gaining, you know, and all of those things. Those things are going to form the basis of how we are going to approach him. And then when you just come, you say, good morning, I am the executive officer, or I am the manager, I am the managing partner of so company. As you know, we are the ones that are in charge of the marks all over this country. And we see that your land is very, very important, and we want to acquire it. How much do you want to sell it? You know, don't even bother your mind about the price, because any price you name, we will pay it. You know, by the time you do that, you may be putting yourself in a difficult position. You may giving them the impression that that place is very, very important to you. And you may be giving them the impression that any amount they call, you know, even if the person wants to sell it for 1 naira, he may be thinking of 10 or 20 naira eventually, or he will say he's not interested in selling. So you must make your research very, very important. Then you need to find out about the other person. Let's say it is not just you want to go and acquire something. When you are to acquire the land, you are going to be the one to initiate the conversation. But if you are going to, if there is a dispute already and you are going as a mediation advocate, as a negotiator on behalf of your client, you need to now find out, like lawyers, you have a case. These people say that the bank removes money from their account without authorization. You know, so you sit down. Is it possible for money to be removed from somebody's account without his authorization? He said, yes, no. Yes, because yes, somebody can hack into your phone or steal your phone, and then he can have access to those information, or he can do this and that. No, because before you can make a transaction, there are some secret codes and, you know, passwords that you need to insert. Are we together, please?
Yes, sir.
Yes, sir.
Yes, I don't know why the time is moving faster like this. So if you are able to think, you are going to be thinking for yourself, researching for yourself, and then you'll be thinking for the other person. You'll be making research, you'll be assessing the person's opposition. What do you think will be the strengths and weaknesses of this person's case? What do you think his own case will be like? What will be his defense? What will he be anchoring on? Why, you know, assuming they want to settle, how much do you think they will settle? So let's say you have a matter in court, and then the matter has been statute bar for people, for those who are lawyers. You know, you are supposed to file your matter within the period of 5 years, and the period of 5 years has elapsed. And then the matter, you have eventually filed the matter in court. So if you are thinking, okay, these people have a right really, but the law says that after 5 years, you cannot pursue your right in court. And then you are coming to negotiate, knowing that these people will not have a case in court eventually when they go to court, actually empowers you to negotiate. On the other hand, the other person will say, okay, yes, our right is extinguished, but you know, this is our fatherland. This is where we belong. Anybody that comes to this place, we have a practice, we'll be sacrificing them one after the other. And if you are not aware, ask around and you will get to understand. So we have to go and appease the gods before they can allow you access to this land. You know, everybody is working on his strength and his weaknesses. And if you don't consider those two aspects, you know, you do not try to assess the position both for yourself and the other person, and you just go there without any preparation, definitely you will not know. When the person is telling you one thing, you don't even have information to be able to counter it. But you see, when you are making your research, you get to know about the other person. Let's say, instead of going straight to the person and say, let's say like women, normally you see a woman you want to marry, you just go straight to her, say, madam, I want to marry you. In fact, you know, if I don't marry you, I will die. You know, you just go and tell her like that, you know. Some people will be like, okay, maybe let's ask the women. If somebody comes to you straight like that and say, you just met for the first time like that and say, now wow, it was you I've been looking for, you are the one, I want to marry you, please, you know. What would be your reaction?
I'll say, you dey Chris.
You not take him serious.
You dey Chris. Okay, you will not be happy that somebody wants to marry you.
Not like that.
You know?
No, it's not that. Please,
No, you know, testimony says that you say you are not serious. So what do you think the person will do to show that he's serious?
In fact, it's gradual.
Or gradual?
He will come always, follow me, know where I'm staying, and he'll be coming every day. I'll say, okay, this man is really serious.
Yeah, okay.
Himself. If he commits himself by bringing his people.
But if you are just sitting at home, you just see people walk into your house, they have not even spoken to you, they have not said anything, they just came to marry you. What are you doing? They brought their people to come and marry you. What are you going to do? You just say, so you want to marry me even without my consent? You've not even spoken to me. You have not said anything. You just brought your people to come and, because you are very serious and you don't want to miss the opportunity. You know, so you see all these things, we are trying to give examples. They are all negotiable. And then there is a way and manner you go about. Let's say if I go to buy the land, or if I'm the one that goes to buy that particular land, I will first of all, maybe when I see the man sitting, I'll go and greet him. Well done, sir, how are you doing? He say, oh, I'm fine. I'll say, Kai, now wow. This one way sit down, relax like this in this hard time. It be like say, Tinubu don't see you. He say, God, forget about that thing, all these things you have to form. You start up the conversation. You know, what are you doing? You are trying to build trust. You are trying to help the person see a friend in you. You are trying to see that beyond what you are interested in, you have interest in the person. So when you meet the woman, for example, and you tell her, oh, how are you doing? Good afternoon. You know, she said, oh, I'm fine. Say, oh, something fell on the ground. Can I help you pick it? And the person will say, which kind of person is this? Where they show me extraordinary kindness like this. Say, okay, no problem. Say, oh, are you going this way? I'm actually driving. I don't mind. Let me drop you. He said, no, 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 I don't enter. I said, no, don't worry. I'm not here to help you. So maybe the first time you see the person and you help her, you know, you will not say anything. You just go, drop her and say, oh, bye, bye. How are you doing? Bye-bye. That is all. The next time you go and investigate, this girl that used to come and stand at this particular spot by so time going to work, where does she stay? You know, they will tell you, is it that fair, dark, tall, young, short lady? They say, yes, she's the one. Say, oh, you see, if you go like this, you corner like this, yes, go down, 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 and then do the U-turn. And when you do the U-turn, you'll be coming up like this, then you see their house. You say, okay, thank you very much. You go and ask another person, then you find out their house. Gradually, you know, gradually. But when you go at first and you just go to begin to say, oh, I'm actually here to marry you. So, and I don't want us to waste time. Let's just arrange and go. Let's go straight away and see your parents. You know, even though you have good intentions, there is possibility that the woman may mistake you. You say, I hope these are not those people that used to come from abroad for sacrifice. They will just go and marry a woman and go and sacrifice her. Why are you rushing? If you are serious, why are you rushing? Then if you start and you are too slow, they say, I don't understand this one. Why are you too slow? Why can't we just marry? So you see, there is every possibility that your good intentions can be misinterpreted. Are we together?
Yes, sir.
All right, thank you. So by the time you are able to understand the person's, maybe, you know, when you get this thing, you discover that the lady is a Man U fan. They say, hey, I just remember though, hey, these people scored so people 2-0. I thought they are serious players. She will look at you, say, look at you, are you a Man U fan? Are you so fan? Say, no, I'm Red Devil. What will I do with Man U? They are not serious. They don't even know how to play. You know, you started a conversation. In the course of your conversation, you'll be able to help the person get to know you. You are building trust. You are building relationship before you bring whatsoever that brought you in. You know, sometimes you can have the first conversation. You say, oh, I hope to see you some other day. And then you will see from the reaction, the person will say, oh, that will be fine. Oh, you don't mind? If you mind, I can come visit you. Is that okay with you? They say, because of the discussion and the conversation you have, the person may likely say yes. But when you go there and then without building any form of relationship, you just go say, how are you doing, sir? Fine. Say, we have come to buy your land. Say, sorry, I don't understand. Did I say I want to sell my land? Do you get? So, but when you get into a conversation and then the discussion is going to say, Kai, actually, you know, I am an engineer. I work with social company. We actually do this kind of, we fix marks around, you know, for network, for people to have, you know, and then we are hoping to bring our marks around this environment so that the people in this environment can have a good network. I don't know whether you know somewhere that may be suitable for us to use. And then the person say, say, Kai, I cannot think of one. No, say, please talk. In case if you think of any, let me know. By the way, I like this your environment. How is it? How about security? All these bad boys, how is it? You know, this environment look like GRA. How did you get this place? The person will even tell you, say, do you know that when I bought this place, I just bought it 15 naira. It was even bush. You know, that's how the person will be telling you a lot of things that, you know, than when you just come without. So that's why you are taking the class, so that you know when and how. And when you are going, you need to do preparation. You need to prepare. So you need to understand the case of the person first. You need to understand their area of weaknesses, and you need to understand their area of strength. And then you need to understand whether the person is desperate or not. If the person is desperate, you know that you may be taken advantage of. So at a desperate situation, get an expert. Get an expert negotiator. Get a mediation advocate to be able to help you in such circumstances. They know how to go about. But when you show say, hey, my
I'm good, yeah. Yeah, okay. Wonderful.
Mr. Nancha might be having network issues. Please soon come on board. Thank you for your patience.
Thank you very much. May Allah help us resolve.
Thank you, ma'am.
You
No.
him so that he can fix it quickly.
Tunina ina ne? Let's stop sharing. Not yet.
Okay, while we are waiting for him, let me engage you briefly. While we're waiting for him, if you have any question, you can ask. Let me take some of your questions before he comes on board. Do we have any question about negotiation? Particularly on preparation stage?
Yes, ma'am, please.
Yes.
Okay, my name is Cody.
Okay.
Good afternoon, ma'am. And
Good
good
afternoon,
afternoon to
everyone.
my fellow participants.
Yes.
Okay,
You
on
won't see
preparation.
Yes, just a minute. You won't see my video because I'm managing the network. I
No
think
problem, ma'am.
that's why Mr. Nancha had the problem. So when he comes up, he has to put up his video too.
Okay, ma'am. Thank you,
We
ma'am.
have to Nigerian network. We must devise means of surviving it.
So,
So
yeah,
sorry for the interjection. Yes, please go ahead. Yes.
Okay, ma'am. On the fourth point in preparation, yesterday we're told that during negotiations, we should be careful about bringing out issues that the parties are not aware of in their case, so that it doesn't seem more like we are taking sides. And then since mediation is also a win-win situation whereby parties, go home making amends and becoming friends rather than enemies. So I'm trying to understand this part of negotiation where assessing the opposition, exposing their weaknesses. How do you reconcile exposing the weakness of your opposition as per going through their the area of pressure or desperation that they have? Do you need to have the weakness that is to expose the weakness of your opposition before you can actually come into negotiation and then forging ahead?
Okay.
Sir,
if you're not talking, can you
mute?
Yes, if
Okay.
you're not talking,
Thank
can you mute? Yes. All right, can you all
Thank you,
hear
ma'am.
me? Yeah.
Loud and clear, ma'am.
All right. On the first scale, your question, the first arm of your question is based on mediation.
Yes, ma'am.
That as a mediator, you are not supposed to disclose information that you gathered, particularly from the private sitting or caucus meeting. Now, the skills of mediation, it's basically skills for a third party neutral. Now, as a third party neutral, you must learn negotiation skills to apply to mediation. During mediation, the hallmark of mediation is confidentiality.
Yes, ma'am.
So if, as a mediator, you enter into a private session and you have a discussion with one party, under the rules of mediation, before you leave that private meeting, you must declare the rules of confidentiality and ask the party again and again if there is any information he wants you to disclose to the other party. If he says yes, then you will tell you what part of information the party wants you to disclose to the other party. Once he gives you that item to disclose, your duty as a mediator is to disclose only that item that the party gives you permission to disclose.
Okay.
Well, the rest of the information, you keep it under your breast. At the appropriate time, you still ask the other party, do you really want this person to know that these are the reasons why you're this hot or this or that. If he says yes, you can still go ahead and disclose. But if he says no, it remains with you and that party at the private session till thy kingdom come, till Christ comes to judge the world. You're not supposed to disclose to anybody. Now, coming to negotiation. Negotiation is a skill for everybody, for your day-to-day relationship with people, your day-to-day work experience, your day-to-day life. Now, when you talk about negotiating on your own terms, you're going to negotiate to have value for yourself. Yes, I can see the slides coming up. It's Mr. Nanchan on ground.
I saw him on video, but he's muted.
Okay, please let
Yes,
him
ma'am.
on. But are you back? Okay, let me round up this question and then hand over the class to you. So when your negotiation skills are first and foremost for you before you can apply it to your parties that are appearing before you. Now, when parties are appearing before you, you are going to help them. Yours is to help them negotiate what to take in and what not to take in, give and take. You're not going to give them an advice. You're just going to assist them. Now, he did make mention of a very fundamental principle that if you have an issue on ground and you discover that it is becoming complex, your best bet is to get an expert negotiator. Now, an expert negotiator knows when to release information and he knows when to attack if there is need to. So there are informations, especially when you know the weaknesses of a party, when you're negotiating for yourself, there are informations you can use in order to gain what you're looking for. But not any information that has been delivered or given to you in a mediation session, in a private session. That you remain with it. You don't have to, you are not supposed to in any way disclose to any of the parties, except you are given permission to do that. Do you have a little clarity?
Yes,
Can you
sorry.
hear me?
Yes, ma'am. Yeah, I can hear you now. Yeah, I
Okay.
was listening. The part that I was a bit worried with that dictating the weakness of your opposition. That was what really
Yes.
got me. As if we want to use it to our advantage rather than coming together and resolving it amicably.
That is using the weaknesses of your adversary is for your own personal day-to-day
Personal,
life.
yeah.
Yes. So your own
Yes.
relationship, yes. How do you
Thank you,
navigate
ma'am.
life, how you go about things, but not when you're sitting at the mediation session.
Yeah.
All
Yes,
right.
ma'am. Thank you so
Is that
much. God
okay?
bless you. Yes,
You're
ma'am.
welcome. Okay. Yeah, Mr. Nanchan, can you take over the class now?
All right. Thank you very much, ma,
You're
for
welcome.
being there. Sorry. We are looking at the stages of mediation. We have looked at the preparation stage. I'm emphasizing the preparation stage because everything you're doing without preparing, you want to send your child to school, prepare. You want your wife is giving birth 9 months, prepare ahead of time. You want to go into business, prepare, make your research so that you not go and buy something that they are selling 10 naira, you buy it at 20 naira, they will tell you that it's because of you. They even gave you like that. So you now come and say you are selling 25 naira and people will be looking at you. How can you be selling this thing 25 naira? So very, very important preparation. Then
Mr.
the
Nanchan,
location.
Mr. Nanchan, just a minute, please.
Yes, ma'am.
I think you should put off your videos while we concentrate on the slides so that the band can be stronger. The network
Okay, you
band is
can't hear
quite
me.
weak. No, we can hear you clearly, but just put off your video so that the participant can concentrate on the slides you're sharing. This will also help you from your own end. The network is weak.
Okay.
All right, that's perfect.
Okay, so the location of negotiation, you want to agree to do a negotiation, don't go to the home country of the person or the office of the other person. Get a neutral ground, right? So that everybody will be neutral on that particular environment. If you go to his house for football, as they say, there is this home advantage. If you go to play in somebody's home, you know, there's every tendency that the person may end up winning because of those things. So try to get a neutral ground where everybody has no any hole, you know. These are all part of preparation. If we are going to hold this meeting, where should we hold the meeting? Now, after that, you go to the proposal stage. You know, there is something you are trying to negotiate about. There is a conflict that you want to negotiate. And then, so when you discuss, you make your preparation and you meet at this point of making your proposals, you know, you are going to be having exchange of proposal offers and counter offers. What do you do at this stage? You need to understand the importance of proposal making. And when you are making your proposal, you must do it in such a way that the person will see that you are confident. You know, if you say, you know, I think I have finished school for a while, and you know, I'm working and they are paying me good salary. I think I'm supposed to get married and I want to marry you. If you speak to a woman like that, do you think the woman will consider you as someone who is serious? Eh? I would like to be seeing your faces. Do you think the woman will be serious? Can you hear me?
Yes, I can hear you.
Yes,
Yes, you can hear you.
So, but you know, when you look at when you are trying to make a proposal, you make it what you have to be confident and you have to be fluent. Say we will give you I think we will give you hi we will give you hi oh we'll give you 20,000. We'll give you 20,000. You know, you are not fluent, you are stammering, and the person will be wondering, this person, does he understand what he's saying? Does he believe in what he's saying? Is that thing coming from him from a position of authority, or are you just saying it for saying sake? So you must understand. So, and then when you are making that, you must give opportunity for negotiation. I gave you an example where somebody who is supposed to exhaust only his limit of negotiation is 10 naira, and he goes straight away and say, we are going to offer you 10 naira. Once you say that, you know that that is all. When the person rejects it, how are you going to start the conversation again for the person to bring it down? You know, so you give a room for some adjustment, for some talking here and there, and then you can say, assuming we give you 1 naira, and then because of the relationship and what you are going to benefit in this environment, will you give us the land? Will you sell the land to us? Say, God forbid, I'm not part of this environment. This is my property. It is not government property. So you must make your proposal hypothetically. And then you must learn to listen. We have learned to listen. We have learned about listening skills, effective communication. If you want to listen, pay attention. Try and be silent. Try to listen. Don't be interrupting the person. Try to understand the person's perspective. And you can only do that when you are listening to the person. Take note of all offers, all proposals. You know, you are writing, okay, this person says I'm offering 1 naira, or okay, I'm going to pay in so installment. This, just take note of all of those things, all the offers, the counter offers, and all of those things. Take note of them so that you can refresh your mind while doing the main bargaining. The person will say, see, if you don't pay us 100 million, Just forget about it. That's the position. Forget about this discussion. Forget about this thing that we're doing. Are we together?
Look, sorry, sir. Yes, we are, but we're really having challenge with some of our participants whose mic is still on mute. It's really
Okay,
noisy.
so we are going to mute everybody.
All right, thank you, sir.
Can you hear me now?
Yes, I can hear you, sir.
Yes.
Yes, we can hear you, sir.
All right.
Yes, we can hear you. Yes, I can hear you.
All right, great. So now after you finish the preparation stage, you go to proposal stage. Remember the last thing we say, take note of all the offers. Then you go to the bargaining stage. Somebody says that you have to pay us 100 million naira with apologies. The other person say, enough. We are not going to pay you anything. There is no need to pay you anything. Those are the offers. Those are the proposals you are making. Then you negotiate. Why are you saying that you are not going to pay us? The other person will be saying, okay, this is the reason why you are going to pay us. All these things will take place at the beginning. Now, when you are negotiating, begin to make concessions on the small issues. The small issues first, things that are not problematic. Okay, yes, you supply 1 bag of rice. Yes, you agree on that. Fine and good. You are going to return. We want you to refund either the money or this thing. Those are issues. Fine and good. Okay, but when it comes to damages, you are going to pay us 50 million naira as damages for this, and that. And you say, I don't think that this is necessary. I don't think that this is necessary, and I don't think we are going to pay anything. That is where the issue begins. Then you have made your proposals. Everybody is aware of the positions. Then it is time for you to do your discussions. This is where you're going to you're going to start making negotiations. Okay, having discussed and you understand everybody's position, this one was able to explain to you and give justification why he must be entitled to damages in addition to what you are supposed to pay him. Then when you are making offer, just as I said, don't go and give everything that you can offer at the highest amount of money or whatsoever that is allotted to you. This is the highest you can go. Don't go and say you are going to give them this amount or so bag of rice to shut up the amount so that everything will finish. No, make the smallest concessions first. Make the smallest concession first. Okay, this one give, you are going to do like this. Okay, I'm going to do like this. Small, instead of 10 naira, which is the highest, start with something small. Okay, let's offer you 2 naira. Let's see how this our relationship will continue. We are hoping that we'll have a beneficial relationship. And the person will say, no, I don't think that will work. In fact, if you are not serious, tell us, let us leave this place. So you need to understand that in the course of your negotiation and bargaining, the person tells you that, if you don't offer us so amount of money, we are going to report the matter to the police. We are going to ensure that so person is prosecuted. We are going to do this and that, right? That is the explanation. That is what the person is saying. But when you are accepting, when you are making a compromise, you say, okay, if you are going to give us, since it's 100,000 naira, you will give us 5 bags of rice, and then you will give us 50,000 naira. If you are going to compromise and accept that offer, you must do it in such a way. If you are going to accept it, Don't do it in such a way that this is my last hope. This is the only option that I have. Oh, let me just accept this thing. No. No, don't show the person that you are already losing. You know, you have lost your ground. So anything you don't have any option. Let me just accept it like this. Are we together, please?
Yes, sir.
Yes, sir.
Now, always learn. Don't ever, yes, don't, good. Don't ever, you know, don't accept an offer or a proposal without receiving something in return. So if the person says, we are going to pay you 10,000 naira, I say, okay, sir, but we cannot pay you now. We are going to pay you in 10 months time. So, okay, sir, no problem. You say, even in that 10 months time, if we are not able to pay you, don't come and disturb us. So say, yes, sir. No. That is not what to do. When you say, okay, you are going to pay us give us 5 bags of rice and 2 bags of this, you say, okay, but if you are going to do that, we will expect that you pay us immediately. Remember, when you are accepting a proposal, don't do it as a sign of loss. I have lost this by gain. No. So what will I do? Let me just accept it. When you are accepting it, accept it in such a way that the person will not see that you are losing, right? And when you are making concession, that concession you have to do it in such a way that the person will understand that you are accepting that thing because of the negotiation in the spirit of togetherness. You are losing something, and always get something in return when you are giving something. That is the principle. That is the thing that should regulate your negotiation. If you want to test the ground, like mediators always do in the caucusing, they want to do some kind of reality testing. You make assumption. Say, okay, we're supposed to pay you 100,000 naira. But you know, because of the difficulty we are passing through, assuming we give you 50,000 naira now, and then we'll pay you the balance in 10 months' time. What do you think about it? And the person will say, assuming. You are not saying you are going to do it, or you are assuming, right? Are we together?
Yes, sir.
You are assuming, you are not saying you are going to do
sir.
it. So you are making an assumed proposal. Assuming we do like this. Okay, assuming we accept this 100,000 naira that you are offering. Can you pay us now and then so that everything goes? Now, always ensure that you receive something in exchange. Always ensure that you receive something in exchange. Don't just consider or accept any proposal without having something, receiving something. Because it will be like there is a power imbalance. Everything you say, okay, yes, sir, yes, sir, yes, sir, let's go on. You know, that something like that. Now,
Question, sir.
When you get to the bargaining stage, you now come to the closing stage. You have discussed, you have negotiated, right? You have finished all the bargaining. Now you are at the closing stage. Now, assuming the money involved in that negotiation is a debt of 100,000 naira, and the person agreed that, okay, no problem, we are going to pay you your 100,000 naira. Say, fine and good. Is that the end? No, you record they have agreed to pay us 500,000, the 100,000 naira. Okay. How do you intend to pay? Are you going to pay at once, or you are going to pay in installments? Oh, we are going to pay in installments quarterly. You record. We'll pay in installment quarterly. When you finish recording everything you have agreed upon, but that our payment is going to commence in 6 months' time, not now. You record that this payment will commence in 6 months' time, not now. Then, when somebody says, for example, I gave you, when a woman tells you, I don't think my husband loves me anymore, I want a divorce. So you see, as a mediator, you need to find out what is the meaning of love in the woman's own perspective. Do you understand? And so in the course of your negotiation, if the person says a word that has the possibility of dual or multiple meaning, let's say, for example, say, oh, glory to God, glory be to God, I am gay. So what? Do you mean I am negotiating with a gay? You know, something like that. Are we together? I want to be seeing your faces.
We are following,
Are we
sir.
together?
Yes, sir.
We are
Yes, sir.
following, sir.
Yes, sir. Yes, sir.
When somebody says, okay, so when somebody says, wow, when somebody says, wow, I am gay, you know, in the course of the negotiation, you have finished the negotiation, and then he makes that impression, wow, I am gay. And then the person will be like, what? What do you mean? You are gay? You know, and all of those kind of things. So they said, try to always what? Find out. Define every word. Don't allow any word to stay there that is ambiguous, right? That you do not understand the meaning. According to dictionary, gay would mean being happy, right? It could be happy. You know, it could be the gay, the one we know, right? So you need to define every word. Record all your agreements. Make every clarification. And confirm the terms. When you finish recording your agreement, you say, sir, you agreed to pay 100,000 naira. Yes, we agree. You agreed to start paying in 6 months from now. Say yes. You said you are going to pay, you are going to give us 5 bags of rice before the 6 months elapse. Yes. You are going to do this so that you confirm that there is consensus. Consensus addendum. According to lawyers, there is a meeting of the mind. You will not be thinking one thing and the other person is getting a different thing. You know, so once you have done that, you know, clarify every word that has any tendency of being ambiguous. And once you have done that, you have come to the end of the thing. Then you have to now see how you can draft the agreement, those things you have agreed. Bring in your legal practitioners, your lawyers, who are going to go and give a vivid legal expression and backing to what you have agreed upon in form of an agreement, so that it will properly capture your mind. It will capture the essence of the agreement you have in the course of the negotiation. Are we together?
Yes, sir. We are following.
We are following.
All right, that's good.
Yes, sir. We're together. We're with you, sir.
Good. Now, having said so, there are some things that can affect the negotiation. Your negotiation, you may not be able to have a successful negotiation because of certain things. Maybe I had in the conversation before, somebody is saying that, just tell the lawyer to leave, excuse the lawyer from the conversation. You have to be very careful because lawyers are stakeholders. Learn to manage them. Learn to put them under your authority in the course of your negotiation. If not, you are going to be having a very difficult time. You know, so a lawyer will tell the client, say, see, if you go there, no matter what they do, don't agree to anything. They just want to manipulate you there. mindset. When you have the mindset that this thing cannot be settled, it may not be settled. When you already fix your mind. So when you're going to a negotiation, don't go with a fixed mindset. You have to be prepared to shift ground. And then, you know, sometimes out of anger, the relationship, the woman has been beating the woman very well. And then she's very angry. They come before a negotiation session. Oh, yeah, talk now. You just put your head one side and then just be shaking your head like this and doing your legs like this, you know. You know, sometimes it's fear. Fear can make negotiations to fail. Sometimes you have exhausted everything you want to do. You don't know what else to do. Now you see, when you are going to negotiate, you need to confirm who has the authority to call this, to make the call. Always negotiate with someone who has the power to say yes, and the yes will be honored, and no, and the no will be honored. Always try to do that. When you discuss and agree with someone that does not have authority, or when you say, okay, we are going to offer 10 naira, then the person says, sir, they say they are going to pay us 10 naira. Should we accept? Say, no, my boss said you cannot accept 10 naira, or the highest is 15 naira. You know, that's a problem. You know, that is going to be some of the things that will hinder. These are some of the causes of bad negotiation. So by the time you negotiate and you get to a point where you see that even when you go further, you have come to a roadblock, there is nothing that can be done again. These are some of the things that you know. These are the causes of the root causes of a bad negotiation. So now, look at when you are going for negotiation, get to understand what you are going there to do. What is the limit of your authority? What are you going to be doing? What is your own value? Do you have a value to offer? You know, so you exchange value, things that are beneficial to yourself. These are the things that you're going to be doing. You need to understand the other person's vantage point. You need to understand, okay, what is the advantages, what is the disadvantages, what is the area of strength or weakness of this person, so that you know how to go about. Now, one important thing you need to do is people always join the problem together with the people, and they just see you say this one is a bad person, not knowing that he's representing an interest, not him per se. So you must always try to separate the people from the problem. And in the course of discussion, try to generate options, several options. If the money is 100,000 naira, you don't have money now, but you have a wife, you have a daughter that you can say, hey, see, you know, the other time you came and we say we are not going to marry our daughter to you, but you see, I have a reconsideration. You know, since you are interested in our daughter and we have this issue, why not let's use it to resolve so you can come back, you know, I will talk to my people and then this matter will be resolved. Always invent options for mutual gain. It's okay, since you don't have money, but you have grasses. These grasses, we will use it to feed our cows. Can you give us the grasses in exchange for our 100,000 naira? And they say, yes, we can do it, you know, generate more options. So don't go with a mindset that is not ready to shift. Always try as much as possible to leave the room open for you to look at some other ideas in the course of the. Now, you know that in the course of negotiation, you have different sets of people. There are people who may be working under. There are people who may have influence over the disputing parties. There are people who may just be even stronger than the people involved in the issue. So you must understand that you in the course of negotiation, you may have to deal with people's perception, people's emotion, and communication. And all of these things, as we have learned before in communication, they could be verbal and non-verbal. When you are talking to somebody and you see the person is putting his head like this, but the person is coming forward like this, is looking at you. Or somebody, the person you are talking and the person's head is this way, or he's shaking his hand, or he's putting his hand on his waist. All these things are a form of communication. You should know that. You know, somebody will say, you know, if it is these people, you know, this type of people, they are like this. Either they are dirty, or they are too clean, or they are thieves, they are this and that. And you already have that perception when you are dealing with the person. Do you know, he doesn't pay his workers. So when you are dealing with the person, you bring that perception, say, this one, even if you agree, will not pay you. That is how it is. You must understand that this is how these people are. These are the things you are dealing with. If you can't prevent any issue or dispute before it happens, but when it happens, you find a way of dealing with it. Focus on the interests of parties, why they want it, not positions. Remember, not positions. What they say and what they want. We want you to pay us 10 million naira as damages, refund our money. We are not ready to talk anything again. These are positions. Interest. Why do they need this thing? Help them see their common interest. You can continue this business relationship together. You know, if you go to court, for example, you know, that's why you look at Watna, your partner. You know, what is the worst alternative to a negotiated settlement? If we don't settle here, what is the next option? Do we go to court? Are we going to spend 6 months, 1 year in court? How much are we going to spend, you know, on lawyers, on court, you know, the time, the value of our investment? How long is it going to take? These are some of the things that you must consider in the course of your negotiation. And you should know whether there are multiple interests. Some people are not directly involved in the dispute, but they will be affected by the outcome of the dispute. So you see, government say we are going to bring down fuel to 10 naira. Then people that are producing the refineries and the rest of it say, if they sell it, if they bring it at 10 naira, what are we going to do? So they start strategizing. We are going to reduce fuel price. They say if we allow them to reduce fuel price, now we have already bought at the higher price. So what do? Let's close down all the filling stations so that people will start suffering. We will sell it through black market, and then we'll recoup our money before government says one thing or the other, or before they reduce the price and all of those things. So you will see that there are people who are directly involved in the dispute. You may just be seeing them, but there are other people who are affected positively or negatively, and they may be doing everything possible to ensure that either the thing works out or it does not work out. So you must understand there may be multiple interests in the course of negotiation. Now, what are the skills that you need in negotiation? We have discussed number one, communication skills. You must understand how to speak. You must understand the skills that you need to speak. When you are going, you have an interest. That's why when you do your investigation, you know how to present yourself to the other person. Know how to present yourself to the other person. If you go without knowing what you want, you know you are going to be a disaster. And that thing you know how to communicate it effectively. Communication can only take place where you pass a message and the person understood the message the way you have presented it. Now, for example, when you say, release them, kill them not. Release them, kill them not. You know, if you have it written, if you have that thing written, you may have difficulty. If we have that thing written, you may see that just a comma can change the meaning of the thing. One may mean you should not release the people, you should kill them. One may mean you should release them and not to kill them. So when you want to communicate very clearly. in such a way that the person who is at the receiving end will actually understand and not misunderstand what you are trying to pass across. That's very, very important. Emotional intelligence. You must understand the components of emotional intelligence, you know, awareness of yourself, know yourself, you know the other person, self-control, and your building relationship. That is emotional intelligence. So if you are able to understand the components of emotional intelligence, you'll be able to actively work out modalities, right? You'll be able to actively be a good negotiator. You will know how to relate with the people on the other side, and you may not end up causing problem for your people. So in conclusion, we need to always remember that negotiation is a vital part of our lives. And for us to get to our promised land, according to the chairman of our governing body, you must have to negotiate your ways through the wilderness. If you want to get to your promised land in any aspect of life, you must negotiate your way. Anything you want to do in this life is negotiation. You go to the market, you are negotiating. You know, you want an employment, they say, we are going to employ you, but we are going to allow you to do like 5-month probation, and we are not going to be paying you. All is what? Negotiation. We say that you are not entitled to join any union. Do you agree? All negotiation. So thank you very much for listening. I think we have come to the end of this particular class. If
Thank you, sir.
Thank you, sir.
If you have any question, feel free.
I have a question, sir.
Okay, go ahead.
Yes. Sorry, during negotiation, sorry, there was a point you made about sorry, I'll get it out. Then maybe you hand over the mic to somebody.
The CEO, can you mute everybody, please? Some people's devices are making noise at the background. Just mute everybody. If you want to ask a question, just raise your virtual hand.
Okay.
Raise your virtual hand, and then you will be allowed to ask questions.
Yes, during bargaining.
Okay, that's Sean.
Yes, sir. I have a question on bargaining.
Yes.
You said during bargaining, you should compromise without putting on a losing face. But I was thinking on the contrary. Don't you think putting on a losing face should attract sympathy from the other party? So that you will think, why should I do to this guy like this? Maybe by putting up a losing face, I would kind of convince him to agree with me that if I go with his own opinion, I would be losing a lot. So I'm thinking putting on a losing face could have been in my own advantage. That's I don't know. That's my question, sir.
Okay, thank you very much for that question. When you go to marry, are you married now?
Yes, I'm married.
You did not tell me that you're about to marry.
I'm married.
Okay, so now if you are going to get married and you go to your in-laws' house and they say you must bring one full cow and bring the tail of snakes, let's say 10 tails of snakes. And you know, since they don't used to, you cannot easily get it, you have to buy it, and then each one is 100,000 naira. You know, so and then you are trying to do a kind of negotiation. Are you going to be presenting, you will help them to see that you are not happy about the request they are making. You will help them see that even from your face, you are looking so sad. When they are saying, okay, bring this, you know, even though you know the thing is burdensome, you will try to find a smile somewhere, you know, and you customize your face in such a way that it will not show a kind of disappointment. Is that not what you are going to do, Mr. Dachon?
Well, I kind of agree with you.
So that's all we are saying. If you are losing something, but you don't need to put a losing face. You are conceding to something, but without putting a losing face. You know, say I gave an example. Everything they are saying, oh yes, sir. You say you are presenting yourself as if you don't have any option or you are so poor. You cannot afford this thing they are asking you, you know, and all of those kind of things. You can go and cry, but not in their presence. You can go and seek for help, but not in their presence, isn't it? No, so in negotiation, everybody is coming there. You are trying to talk on behalf of yourself or on behalf of another person. So you don't need to be presenting a kind of I've lost hope. When you see someone who is hopeless in a situation, you will know, right? So you are not there to go and show them your hopelessness. That's why you see they say some people living in Abuja, they don't have a house of their own. They are living inside their car, but they have big cars. They have big babariga. When they wear it, even the man on the gate, you will salute them and they will enter. But when you go like this, wearing just your t-shirt, or even when you wear correct suit and you go there and you are trekking to the place, they say, excuse, shift from the road. You know, that is the thing. You package yourself. Even if they are asking you to do something that is very difficult, you say, okay. You can't tell them, say, sir, please help me. You know, I'm coming from a very poor background. I cannot do this thing. Please just help me. You say, okay, sir, we have heard you. Yes, we are going to get back to you, definitely. Yes, we'll get back to you. You know, that's how you present yourself, not as someone who is so helpless in the situation and you cannot do anything. Do you understand that, John?
Yes, sir, I do. Thank you.
Why attempt your question?
Very well, sir.
Thank you very much. Helen, I can see your hand.
Yes, sir. Thank you so much, sir. My question is, I think your disposition going into a negotiation would be to get something out of it that would benefit you. But now you've been emphasizing on we saying things that we should present ourselves as, even though the negotiation is not favorable to us, we should not present it there as it not being favorable. But I'm thinking, going to the negotiation is not to get an outcome that would be beneficial to us too. How do we go about that? Even when they are presenting certain offers that we know honestly would not benefit us, we cannot just present to them and say, okay, no, this offer is not going to be helpful to me. It won't benefit me. It's only going to be it's a bit imbalanced. It's benefiting you people more than it benefits me. But
Okay,
from what I got from your lecture,
Helen,
you
I
said we
think I
shouldn't
understand
go
your
about
question.
negotiation like that.
Helen, I
Okay,
think
sir.
I understand your question. Now,
yes, sir.
If I get you correctly, the answer I gave to that one is maybe the foundation of your question, right?
Yes, sir.
All right. Now you see, remember in the course of it, I say you are going to do your homework. You are going to do your research. You are going to do your preparation. You get to know about the strength and weakness of the other person's case. Do they have a defense? Do they have something that will support them? You look at your area of strength and weaknesses, and those are the bargaining chip. If the thing gets to the worst, you say, okay, what is the worst alternative to a negotiated settlement? Say, sir, if you go to court, for example, Now, this matter is already 5 years, and then you cannot succeed in court. That's a disadvantage. That's something you can use to negotiate, isn't it? But we have said that when you are conceding, when you are giving something, don't just give something, receive something in return. Are we together? That's why you are an expert. You are being trained so that you prepare yourself ahead of time. Do a proper preparation, because he who fails to plan has planned to fail. Do you understand, Helen? It's not as if anything they are telling you will be accepting it. No. But if you are going to negotiate, you must have done your background check. You must have done your homework. You have looked at things from the person's perspective, and you know areas of strength and weaknesses, areas you can be triggering. You can throw this one and see whether it can get something for you. So I said, if somebody is saying that, okay, the last we can offer is 10,000 naira, you don't now allow him to now tell you when and how he's going to pay that 10,000 naira without saying something that will help him see that you are negotiating. It's not as if there is any power imbalance. So you are going to give me 10,000 naira. I say, okay, but if you are paying me 10,000 naira, I'll expect that you pay me now, instantly, or within the space of 1 month. So you can see you are making a request. It's not as if you are accepting, as if it is a favor the person is doing to you. Do you understand, Helen? Helen, do you understand?
Yes, sir. Thank you so much, sir. I do.
Did I attempt your question?
Yes, sir, you have.
All right. Glory.
Yes, sir. Yes, my question is this. On defining your role as a negotiator, you talked about separating the people from the problem.
Yes.
And now, I want to ask, is it in all situations? If it is not, or if it is, I want to put this scenario, because at times, maybe you go to buy something, and before you go, already they tell you, see where you are going to buy that thing. These people can cheat you. Maybe you want to buy Belgium, and they will tell you, look, this thing is Belgium, and it's not Belgium. So already you know that they've told you that these people can cheat you. And you now get there, and you now see them exhibiting what they have told you. Now, is it that it is because of your mindset that you observe that they are cheating you? And now, and you have the people, you have the problem. So how do you go about that? Do you walk away from the negotiation, or you just, say, oh, okay, this is what they've told me, and then you keep negotiating based on what you have already known about them? Because I was wondering, if they tell you these people will cheat you, and you go there and you see them actually doing it, how do you separate the people from the problem? Because you've actually seen it happening. What do you do in that instance?
Now you see, if I go to the market for something I've never bought before, let's say I'm going to buy this phone. I'm going to buy this phone, right? And I just went to a shop. They can tell me this phone is 500,000 naira. Because I do not have an idea of how much this phone is, there is every tendency that they may cheat me. Somebody can be cheating you and he will be telling you it's because of you. That's why he's giving you. If you have done your homework before then, what are you going to do? You go there. What I do sometimes, I will go to 2 or 3 shops, assuming I don't know and I don't have anybody to call. How much is this phone, this particular brand? They'll tell you 150 here. This one will sell you 200 here. This one will tell you 120, but bring 100,000 because of you. You see, I have done a little investigation and I have an idea how much. People are doing business to make money, and they can do anything to get the money if that is the essence of the business, right? So I need something from you. I will not go with the mindset they say, hey, if you are dealing with a Yoruba person or with Igbo, for example, they say they like money. So if you are dealing with Igbo person, you have to be very careful and all of those things. Then you go with that mindset. This might looks like an Igbo man. They have won me already. You are going to have difficulty in your transaction. put the personality of the person aside. He may not even be that person. He may be that person, but the person has what you need. When you are going there, I want to buy this phone and I need it. Whether you are an Igbo or you are not an Igbo, that is none of my business. I want to get it at an affordable price and I don't want you to cheat me. Simple. So how much are you going to sell this phone? 15 naira. That is the price. I say, okay, this 15 naira, you know, if I buy this phone and people see it in my hand, right? They will begin to ask, where did you buy it? You know, everybody now, I may be bringing them to your shop. They say, that is true. You know, we want to establish relationship. I say, oh, that is why I've come now. So look at it, consider. Say, but I thought they were selling this thing 15 naira. When did you increase it? These are negotiation strategies. You need to develop it. And you develop it in the course of practice. I may not know the price before, but my
network.
Hello, sir. You're not audible anymore. Hello, sir.
We can't see your voice, sir.
Hello, can't hear you, sir.
I hear you, sir.
I guess he's having network issues.
Yes, I can't hear him again.
Let's just be patient. Good afternoon, participants. I'm sure he had some network issues. Mr. Nachang will be back shortly. Thank you for staying put. Happy New Month, everyone.
Wish you the same, sir.
Happy New Month, sir.
Thank you so much.
Hello, can you hear me?
Yes,
Yes,
sir.
we can hear you, sir.
Yes, we can hear you, sir.
Sorry for that
Yes.
network interruption. I believe that I have answered the question, right, Gloria?
Yes, yes, sir. Thank you, sir.
Thank you very much. So I think we have done wonderfully well. We want to see how we can utilize our time. So we are going to have Let's see. Those that have logged out, I expect them to be in. We are going to do our practical simulation. So I just want you to take like 2 minutes to stretch yourself, and we will break you into groups. This is 1:35. By 2 o'clock, we should be back. By 2 o'clock, we should be back so that we will take Mr. Samuel. Mr. Samuel, are you with us? Hello? Mr. Samuel is with us. So please, your friends who are out, tell them to come in. We are going to have a practical session. I just want you to stretch yourself, stretch your legs. We are supposed to have a little break. So we are going to use that break to go into our breakout rooms and do a kind of simulation. You have question number, you have practical simulation number 1. Can we take it? Or do we take?
Yes, you can take it, sir.
It's on there, debt recovery, sir.
You can take it, sir.
Hello?
Yes.
Are we together?
Yes.
Okay, so
yes, sir.
we can take it, right?
Yes, sir.
Okay, so I'm going to break you. You can see this is just 20. We will break you into groups, and then you do the first practical. You assign your mediator. You have just like 20 minutes to do so. So if you see a pop-up on you're going to, okay, we'll allocate you automatically, just join your group, and then you use, what is practical number 1? What is it?
Debt recovery.
Debt recovery.
Okay, debt recovery.
20 people, and minus some people. Let's say we have 15. Let's break into groups of 3 and see. 3 people into 20. How many groups do we have? 3, 3, 3. That's 6 groups.
6. Yes. 6.
So let's have 6 groups. Just open. Once it's open up, assign a mediator and if the parties and go straight. You just have 20 minutes to do that. 3 minutes to 3 minutes to be able to clear your decks, and then you do that. We'll be visiting you from place to place, from room to room, to see what is happening. So if you see your group, just click and join. Click and join the group and start immediately.
Hello, Mr. Nachan.
Yes.
Can you hear me? I'm sorry, I got logged out. I didn't get the.
What group are you?
Sorry,
Eh?
I didn't get. Can you hear me?
Which group were you?
Group?
Yes.
Aside that, the group of banking and the simulation we used yesterday. I got locked out. I didn't hear what you were saying.
I said we are dividing you into groups. So I will send you to a particular group so that you will join them.
Okay, sir. Okay, sir.
Okay, I saw that I'm in group 5, so but I wanted to get the instruction because I jumped into the group. I needed to get the
Okay, you are in
instruction.
group number 5. You are going to consider me scenario number 1.
Okay, that's
yes. So scenario number 1, and if you are in group 5, let me see group 5 and see where I will assign it to. You are Dana, you are in group 5, huh? That's
yes.
Group 5. I will send you to group. Okay. Sarah. That's you need to join group 5.
Okay. Where can I join, sir?
You see a pop-up now on your screen. You join.
Okay.
The guys you hired to kill me, they have been and they confess. This trip I have there is it measures 6 inches, okay? So the width of it is 6 inches for each strip. So this strip I'm going to fold it. I will use one to illustrate. So I'm going to after we have joined the front and back, I'm going to the front back. So let us join the shoulder line. I'm going to my machine now. I'll join this together before I get to run all the way. Shoulder line. Oh, is there a new branch ever since that is coming to front dress? So for the front dress, I'm going to show the shoulder line. Because you're not waiting. If you want, you can take a measurement of that is how many although I've already making it of half a yellow fabric which I've already cut the strip. But I'm still going to measure from the one edge of the keyboard after join. That's
Okay, so Dachom, you are still here.
I'm still here. Oh.
Gloria.
I'm still here. Maybe if you can send it this thing again.
Miriam and Jude, you can actually start a group. Let's see.
Let me see.
Gloria.
It seems they are not close by.
You change. Oh, let me see your face when I'm going back. You are not sleeping, Gemma.
Mariam. Jude, Glory. Where are you? Mariam, where are you? Dachom.
Yes, I'm here, sir.
You are supposed to join your group.
Okay, I joined, no, but when I discovered that I've not gotten
Yeah, I have
instruction.
assigned you to group 5. Check your screen. Are you using phone or laptop?
Laptop.
Okay, you will see something like a box with different this thing. When you click on it, you see different groups. You choose the group and then you go there. Glory, can you hear me? Mariam.
Hello, can anyone hear me? Mr. Nacham.
Yeah, can you hear me? Um, Janet, can you hear me?
Yes,
You can
I can
actually
hear you.
join any of the group.
I can. You said?
You can join any of the groups.
Okay, make me a co-host, please.
You can.
Okay. All right. Hello, Gloria and Nafisat. Were you assigned to a group initially, or you are just joining in? Hello, Gloria. Nafisat, can you hear me?
Yes, I can hear you. Good afternoon, ma'am.
Good afternoon to you. I was asking if you were assigned to a group initially or you just joined.
No, I was not assigned.
Okay, so let me talk to the host.
Those who are, Mariam, have been calling her, she has not been responding. Those who are co-hosts, Glory, which group are you? Glory, which group are you?
No, sir. I'm just coming. I have a low battery just to power a little. It's still low even. So I don't know my group yet. Let me check. Yes, sir. Participants.
Welcome, everyone.
Thank you, sir.
Okay, Mr. Samuel, are you with us? Mr. Samuel.
Good afternoon, Prof.
Okay, so we'll just round up so that you can take like 45, 50 minutes to take that your class.
Thank you, Prof.
So that Mr. Victor can come in at 3.
Thank you, Prof. The
So
husband of one
how many of
female
you
wife.
were able to conclude your mediation?
We were able to conclude ours.
Wow, that perfect. Can you tell us the outcome?
We are also able to conclude.
Wow. Okay, so a representative should tell us the outcome.
Well, for our group, we first of all, there was a strong assumption on our own part that Mr. Musa to submit himself to the ADR for settlement, there was a presumption on our own part because there was nothing in the simulation that shows how the money was given to him, whether it was by bank transfer or whether it was cash. So we feared if it was cash, probably there was nothing to pen him down. You probably raise a denial. So, but we assume that the money was transferred into his account. He knows fully well that there's something to hold that we can use against him, which we assume is a bank transfer. That was why he submitted himself in the first place for the settlement. So at the point of settlement now, what we concluded is that one, there must be an agreement written. And in that agreement, we concluded three things we said should be contained in the agreement. One is that there was an acceptance of liability on his own part, that's on Mr. Musa's part, that he collected the sum of 1.5 million naira from Mrs. Musa. That's the first. Then the second one is that we also agreed that he should be given a period of time. This we're saying that basically from his own point of view also, that he also agreed that time should be given to him within which he will pay. That's the second point in the agreement. Then thirdly, that his failure to pay at the prescribed time or the duration given to him will not have any option but to recourse to the court of law for the recovery of the 4.5 million naira. So those are the three things that we negotiated upon at the point of settlement, the settlement house, and an agreement was entered into. Thank you, sir.
All right, thank you. So which group again finished?
Group 5.
Okay, tell us the outcome.
Well, group 5, we had a very successful negotiation. First, Mr. Musa.
Who was the mediator?
Okay, I was the mediator. I'm the mediator. Then Mr. Raji stood in as Mr. Musa, and then Helen.
Okay, so what was the outcome of the negotiation?
The outcome is that Musa pleaded for time between today and Saturday. He will get the materials as in the next 3 days. He's going to get the materials for Mrs. Musa, and she was willing to accept that offer. In fact, she was the one that gave him that condition, and even though he was pleading for 2 weeks, for at least 1 week, but she said no, she can't go beyond that, and he said he will try and bring it within 3 days. So that was the conclusion of our negotiation. Can you hear you, sir? Hello?
Which other group finished?
My name is Malika. I was the mediator in my group 1. Hello?
We can hear you, ma.
Oh, okay. Thank you very much. I was the mediator for group 1, and we had a bit of proposals and counter proposals from the party. Mr. Musa accepted liability, but he was bringing up proposal that Mrs. Musa wasn't quite happy about. But at the end of the day, we got to a point where he said he was going to be able to deliver 50% of the materials so Mrs. Musa could start the business in a way and still make something. But the only ground that they didn't pay the balance in 4 months, and at the same time, after the 4 months, now pay off the balance in 3 installments after the 4 months, which Mrs. Musa, of course, said that wasn't
Okay,
she was
thank
not going to
you.
agree on
Thank you
that,
very
but
much.
that was okay. So at that point, yeah.
Hello, can you hear me?
Loud and clear, sir. Sorry.
All right, thank
We
you
can
very
hear you
much.
loud and clear.
Thank you very much. You can see that we all had negotiation in different groups, the same facts, the same circumstances, but different results. Right?
So we did report ours, so room 3.
Okay, group 3, what was your...
Thank you. Good afternoon, everybody. Good afternoon, sir.
Good afternoon.
Yeah, at a point, I was the mediator, Cody is my name. Our group leader, Madam Sarah, also gave us the positions, myself as the mediator, her as Mrs. Musa and Mr. Musa. But we had a little bit of challenge with Mr. Musa. But we were able to raise the fact that Mrs. Musa had already collected this loan from the bank. And within that 1 month, that was the delay where Mr. Musa was nowhere to be found. She had already incurred a 10% interest to the economic bank. And since Mr. Musa did not meet up with that, she was claiming for damages and the liability of paying to the bank an interest of what she had not even commenced in the first place. So after much back and forth, Mr. Musa accepted to start the construction of the fish farming, and then they met halfway because the bank is not aware of his being unavailable, since there was a collateral already on ground for Mrs. Musa. So they came to the agreement that both parties will have to pay 5% each to avoid Mrs. Musa incurring a debt of 10% interest, even when the business hadn't even started. Thank you.
Okay, thank you very much. You can see that the same scenario, different results. That is the options that are open to mediation. In mediation, you can have the same facets of five, but different results. And it also depends on the mediators, how they are able to effectively help the parties get to a solution. We are going to have more simulations. Those who have served as mediators can be parties so that everybody would take part, and serve as a party or a mediator one way or the other. Thank you very much. Our very esteemed facilitator has been here with us, Mr. Samuel. We have to bring his class to today because I said do. So please, Mr. Samuel, have the floor. You have about 40 minutes to take that class before Mr. Samuel, Mr. Victor comes in. Wow, I can see that you are now a tradition.
Thank you so much, Mr. Nachang. Please confirm if you can hear me.
Yes, we can hear you.
Yes, we can hear you, sir.
We can hear you loud and clear.
We can hear you, sir.
Good morning, good afternoon, good evening, depending on your time zone. Let me begin by appreciating the husband of one female wife for giving me this platform to
Yes, so
to bring this topic. I've been following the classes. I want to appreciate everyone for staying put. Please permit me to just share my screen if you don't mind. Please confirm if you can all see my screen.
We can see.
we can see it,
Yes,
sir.
sir.
Yes, sir. Yes, sir.
Thank
Yes,
you.
we can see it, sir.
And I hope we know that for the next few minutes we'll be interfacing together, learning from each other, and I want to employ you to make the class as interactive as possible. And if you are not on the call, please do it to mute your mic so that we can have a seamless session. Happy New Month, everyone. Welcome to a new month. Wishing you the best in this new month. In this session, we'll be looking at charging for ADR services. I remain Samuel Robosa Hussain. The next few minutes, 45 minutes, should be done with the discourse of the day, charging for ADR services. Now, it is my expectation that at the end of this session, we should understand what service charges are. We should understand what schedule fees are. We should be able to understand who a dispute resolution specialist is. We should be able to look at category of fees, the dynamics of analyzing costs, understanding your why, useful tips and career opportunities in alternative dispute resolution, learning the need to learn and develop yourself consistently and continuously, finally on how to make money. Reference, pay full price. Do we agree to this? All right.
No, sir. No, sir.
No, sir.
Yeah.
They want
They
to
don't.
pay.
Can someone read what we have on the screen?
They say business thrives when friends and family pay.
Pay for what? Can you complete it?
Pay for services.
Pay for services or their debts.
Pay for services rendered. Thank you so much. Yeah. Now, I want you to please help me answer this. What happens? We all have devices, and I'm glad technology has come to bear. We all have devices that we use to make life much easier for ourselves. Permit me to quickly chip in this. I was on ATM queue one day wanting to withdraw money. There was an advanced woman in her front, and she delayed in withdrawing her money.
Mr. Samuel, your voice is low.
And this one needs to run down the button.
Your voice.
Hello. Can you hear me?
Yes, sir.
Oh, is it better now?
Yes, sir.
Yes, sir.
Thank you so much. Thank you so much. Right. Let's just make progress. We'll all have devices that we use to make life easy for ourselves. Now, what happens when we do not charge our devices properly? Can I get a response? We have our mobile phones, our laptops. When we do not charge them properly, what do you think will happen?
They will run down.
They will run down. Thank
We'll
you
go
so
broke.
much.
We'll also miss out on some information or vital connections at the point is down.
Kodima, you are a prof, and I appreciate you so much. So in order for us to sustain the utility we derive from our devices, there's the need for us to keep them charged properly. All right. Now, a fee, what is a fee? Can someone help us read what we have?
A fee is a fixed price charged for a specific service.
Thank you so much. A fee is a fixed price charged for a specific service. Can somebody else read the next display?
Fees are applied in a variety of ways, such as costs, charges, commissions, and penalties.
Thank you, Kodima. I appreciate you. Somebody else?
Fees and charges means all fees and charges authorized to be received by a specific authority.
Thank you, Solomatu. So a fee is a fixed price charged for a specific service. Basically, what we want to emphasize in this particular slide is that you don't just charge arbitrarily. It must be subject to authorization. So looking at the fees to be charged in ADR, it is being subjected to authorization. Now, how do you explain a service charge to a client? I want to appreciate the CEO of Shati for taking us through that wonderful session on negotiation. Now, permit me to ask, do we have any businessman or businesswoman among the participants? You're into business. Do we have anyone like that? Among the participants, anyone engaged in business or you're into marketing? Anyone? Or have you ever sold any item before?
Sorry, sir, I didn't hear that.
Yes, sir.
Okay. You have been able, you have sold an item before, right?
Yes, sir. Yes,
Thank
sir.
you. Now, in selling the item, how did you convince the buyer to pay for the item you were about to sell?
Sir, I first of all started to show the client or the customer rather
Okay.
his need for that particular product which I am selling. I explained to him how much of a necessity it is to him at that particular moment. And then I told him, I convinced him of its affordability as regards in balance with his need for it, how essential it is to him, its necessity, and the price. I showed them how affordable it could be, how affordable it is rather, and how much of a need it is to them. And then that joined hand in hand to convince them for them to get it actually.
Thank you so much, Helen. You are a great woman. I appreciate you. Now, permit me to ask, do we all agree that as ADR practitioners, we should charge for the services we render? Should we charge or we should not charge?
We should, sir.
We should, sir.
Okay.
We should.
Okay. Glory, I saw your name. If you believe we should charge, why should we charge? Can you explain, or can anybody explain why should an ADR practitioner charge for the service he or she renders?
Because we are providing services that is useful to them or beneficial to them.
Thank you so much, Madam Glory. Thank you so much. I have been opportunity to sit with different parties, and I met a man while sitting with them. When it got to the issue of fees, he told me that he has lived in 5 countries in Europe and that he has never heard where parties need to make payment for an ADR session. I smiled. I appreciated him for making his own personal thoughts known to me. And while we were talking, a counsel on the other side said, you have lied. That is not true. I immediately intervened make the other counsel to understand that everyone has the right to air his own opinion. I asked them a simple question. For the past 3 years, you have been having these issues. They said yes. Have you been able to make significant progress? They said no, that they were once in court and they are out of court. And I told them, what you're about to pay for is not based on the ability for you to resolve or not to resolve. It's based on the ability and the platform being provided to you as far as ADR is concerned. When you're in litigation, you are seen as being on divided platforms. You are trying to put it to him. The other party is trying to put it to you. But right here, where we are in ADR, look at the environment you are sitting. Are you not comfortable in the environment? They said yes. There was a little substance in front of them, a little refreshment. Don't you appreciate what is before you? He said yes. And I asked him, do you think you need to make payment for this institution to give you a platform to explain to the other party what you've not been able to explain to them for the past 3 years? He became quiet. Let me state here that payment in ADR session is not for the outcome, but for the process. When you are charging fees, your fees are being charged not for the outcome. It's not based on the fact whether parties settle or do not settle. Payment is not made whether parties resolve or not. Payment is strictly for the process, and it is advised that from the beginning, parties understand what they are coming into and the fee that they need. So what they are paying is the professional fee that the parties need for the process to move on. Service charges allow businesses to continue providing excellent customer support and products. If service charges are used to improve the quality of product or services, customers will be more likely to return. It therefore means, even as we delve deeper to unravel the dynamics involved in charging fees, as ADR practitioners, we should understand that the fees we get as remuneration for the services we render is not just to while away the time, but to enable us improve on ourselves. Because when we refuse to improve ourselves, our services may become obsolete and we may no longer be in the market. So the fees that we receive, a good part of it is to enable us improve ourselves. ADR services are vital and add enormous value to the lives and businesses of people. Permit me to state here that ADR is a profession. ADR can be a career path. I'm sure when we were registering for this training, we were not discriminated along the lines of our profession. We were not discriminated along the lines of our career. ADR is open to both lawyers and non-lawyers. It can become a second profession for you. There are so many legal practitioners in their chambers. They also render ADR services. So you can decide to specialize as an ADR practitioner. You can also decide to add it to your skill and to your career. ADR practitioners deserve decent compensation. Basically, what we are saying is simple. As a lawyer, as an accountant, as an engineer, as an educationist, no matter your vocation, you can pursue a career in ADR. It can become a second stream of income for you. And as ADR practitioners, we deserve decent compensation. In most cases, we may render pro bono services, making our services available for free, but it is usually not in all cases. Now, please, if you don't mind, looking at this picture, can somebody tell me what you can make from this picture?
That's the picture of a mechanic, an automobile mechanic, maybe.
Okay. Madam Gloria said is an automobile mechanic. Do I have any contrary opinion?
No.
Wow.
No.
So we don't have any matter to mediate here. We are all in support. Thank you so much. Now, there's a little story here. A man at some point was traveling, and while he was on the highway, his vehicle developed fault. He was able to call different roadside mechanics, but they were unable to resolve the issue. And someone had to tell him, if you take a vehicle to a certain location, ask for Mr. XYZ. If he's willing to accompany you to this spot, he should be able to help you resolve the issue. He embarked on the journey, went as far as getting the man. When they came, the man told him to sit in his car, told him to turn on the ignition, and in less than 2 minutes, the car came alive. And the man put his hand, having spent money with other guys, he just placed his hand in his pocket and gave him an amount of money. And the man said, no, my fee for this is 10,000 naira. The owner of the vehicle was alarmed. What have you done that I should give you 10,000 naira? And he said, the 10,000 is not just because of what I've done. It's based on the experience I've gathered over the period of time that enabled me to do what I've done in about 10 minutes compared to the number of hours you have been stranded. Please, can I ask you this question? From this story, do you think the fee the man charged, is it justifiable or it was exorbitant?
It's justified, sir.
Thank
It's
you,
very,
Melody.
very justifiable.
Very, very justified. Thank you so much for your response. What are the lessons we can learn from this short story I just shared? What lessons can we learn?
We deserve payment for our services rendered.
Okay. Madam Clerk, we deserve payment for services rendered. Thank you. Any other comment?
Acquiring skills and knowledge is important.
Acquiring skills and knowledge is important. Thank you so much. Now, bringing this. Yeah. Monday, go ahead, please.
I like that the quality of service we give will determine the amount we receive.
In fact, at this point, if Mr. Natchang, the husband of one female wife, will permit me, I think my job is done. Because I'm so glad I'm learning so much from all of you. You've been able to understand the basics of this session. It is true that we desire so much money, but the money we desire must be a reflection of our experience, our knowledge base over a period of time. If you don't mind, I hope I do not bore you with these following slides based on the fact that you've understood where we are going to. Factors to consider in charging fees in ADR. The qualification of the practitioner is very crucial. Some persons may say that some persons may not be qualified, but they have the skill. Another school of thought believes that qualification is key because it opens doors to you. I was in a training and it was being said that the first 5 best mediators in Africa, General Olusegun Obasanjo, is one of the most sought after mediators in Africa, but he has no qualification in mediation. I'm not here to dabble into that, but I'm saying that qualification to a large extent can help you determine the scale you fall into. At the secular level, when you're looking for an employment, you will always be asked, what is your qualification? The amount to be paid someone that has an SSC result or a WAEC will differ from the amount that will be paid someone that has a HND or BSc. Someone that has a master's, he will also have a different scale of remuneration. The same applies in ADR. Your experience, ADR practitioners with extensive experience handling complex cases can justify higher rates than those that are new in the field. Someone that has spent 30 years as a practitioner, you don't expect someone that is just 2 years or 3 years or 4 years in the field to get as much as someone that has spent 30 years. Talking about credentials, the more credentials you have, the more your rate will increase. ADR practitioners who have undergone advanced training can charge more. Beyond your experience, beyond your credentials, if you've been able to attend so many trainings to a large extent, your stock value or your network, we appreciate. At this juncture, permit me to say to you, if I tell you I'm just 4 years old in ADR, will you believe me?
No.
Not at all. Not at all.
Not at all. I won't.
You won't believe me, but I came into contact with ADR for the first time about 4 years ago. And under 4 years, I've given my spirit, soul, and body into the profession because there's a passion in it. So most times, your experience, your credentials, your training may not be a function of the duration, the times you have spent, the years you have spent. It may just be a function of your disposition. I had to bring this in so that you don't start thinking, I need to wait for 5 years. I need to wait for 10 years. No. If you are diligent and resourceful and resolute, you can make significant progress in a very short period of time. Now, beyond the personality of the ADR practitioner that is about to handle the case, don't forget, if there's no dispute, then there's no place for ADR. So ADR exists because of disputes. So you don't just look at the experience, credentials, or training of the ADR practitioner that is about to handle that matter. You also consider the characteristics of the case, the complexity of the case. The more complex a matter is, the more fee it will attract. Most times, the duration of a matter may have an impact in the fee it will attach. In some cases, they will tell you, if we can resolve this matter in 3 sittings, in 1 month, in 2 months, this may be the charge. But if there's an extended period of time, it may incur more cost. Usually, the location to an extent may affect the fee to be charged. If you have a business outlet in Port Harcourt and you have another branch in Benin City or in Enugu, you have a different outlet in Lagos, I want to believe that if you are giving the same type of business, will you charge the same amount in your different branches?
No, sir.
No, sir.
Why will your charges be different?
Because
some of the states are commercial, they are commercially situated in a very high density.
Thank you so much. You all are scholars. I'm glad to learn from you. So in some cases, beyond the complexity of the case, beyond the time to be invested, sometimes we may need to look at the location. But like, permit me to say at this juncture that it may not apply to everyone, but in most cases, look at the location to determine the cost that will be attached. Now, other factors to be considered include expert determination where applicable. What does expert determination mean?
There are some cases that are complex in nature that you can only resolve it through expert determination. If the matter involves paternity issue, no matter how skilled you are as a mediator or an arbitrator, no matter your disposition, there may be the need to seek the services of a skillful, someone that has been trained to carry out paternity DNA test on the parties. We had a case we were having at some point, and having been able to resolve some of the issues, we got to a particular action that was carried out based on a receipt that was presented. The receipt was presented, and based on that receipt, one of the parties carried out an action that was later deemed illegal. His argument was, this was the receipt that was presented to me, and you signed it. The other party said, I never signed that receipt. When the receipt was presented during section, his name was there. His signature was there. But he said, I did not sign this signature. He confirmed that the signature belonged to him, but his position was, I did not sign it. The matter now took a different turn. It was a different twist as far as we were concerned. I don't think any mediator or any arbitrator will possess the skill to be able to ascertain truly if that man signed it or not. What did we do? We engaged the service of a forensic expert. The forensic expert was called in, and it was his job to determine if, if the man has said, this is not my signature, that would have been a different case. But he said, this is my signature, but I did not sign it. It became very complex. And so the services of an expert determinator was brought in. But before you proceed to use an expert determinant to have a say in the matter, both parties must agree to the fact that they want to engage the service of an expert. And there's a documentation they need to put in that whatsoever be the outcome, they will accept it. When they agree to this, they sign the necessary forms. The day the documents were presented, all parties were involved. The cost of the transportation, the cost for the forensic analysis was borne by both parties. And at the specific time, the result came back and all parties knew the outcome. If a matter at some point we need the services of an expert, it therefore means that the cost for that process will be included in the entire cost. The services of a neutral fact finder may also be necessary. Most times, there may be some disparity in some claims. If it's a building project, a construction project, the mediator and the parties may decide to visit the site to ascertain the claim. But if they are unable to go, the services of a quantity surveyor may be needed to ascertain the quality and the quantity of resources that has been expended on a particular project. The contractor may say, I have spent XYZ on this project. The owner of the project said, no, if you have spent such an amount, by now the project should have progressed significantly. Instead of going back and forth, you can seek the service of a neutral fact finder to go evaluate the true picture and come back. He must be an expert in that field. If it is a financial dispute, then you need the services of an auditor, a certified auditor, to look into the issues involved. It therefore means if an ADR expert is also a quantity surveyor or is also an accountant, his services can be brought in this particular matter. There was a matter we handled. A man brought a chief saying that he's building on his site. And while the session was going on, so many back and front, the chief said, I have not begun any building project. The man said, no, he has done investigation. There are chips of sand and there's a foundation on his land.
And from investigation, it is the chief that has instructed such an act. What happened? A neutral fact finder was involved. He went to the said land. He confirmed that these two persons actually owned land in the same plots, but their lands were not in the same location. Most times, you may even need the services of the town planning organization to confirm the ownership of a particular land. So where all these professional services are needed, it must be added to the overall cost. And usually in sessions, the cost is split between parties, 50% to the claimant, 50% to the respondent, or the parties on their own may agree to a different sharing formula. A party once told me, I was opportunity to sit before a professor of law that who lectured me when I was in school. He took me in the year 2003. I was sitting before him and he told me, they brought us here. We will not pay a dime because they brought us here. It should be their responsibility to pay for everything. And at the end, I appreciated him for expressing his thoughts to me. And at the end of the session, he appreciated why he needed to commit himself to the task. There are some specific and there are some complicated issues where one party may decide to bear the cost of the entire process just to move forward. It differs from one to the other, but generally, both parties are involved in. There was a case I was involved in. I discovered that the respondent will be unable to make payment, and I asked the claimant, both parties are supposed to partake in the fees, but will you be willing to make payment so that we can make progress? The claimant said, yes, I'm willing to make payment. And under 3 weeks, that matter was resolved. We must understand that in costing for ADR services, number one, the experience, the personality of the ADR practitioner should be considered. The more experience, the more his credentials, the more his training, the more fees that he will attract. The nature of the case should also be considered. How complex is it? How simple it is? What are the parties involved? The more the parties, the more complex it may look like. Finally, what do we need to bring this matter up? Are there extra services that will be rendered? Are there extra parties that will be brought in? All of these are put together in determining the cost for this session. In some cases, no matter all the factors I've mentioned above, when you look at this, the economic position of the parties, you may be forced to have a rethink in the fees. There are some persons, it is so clear that despite the nature of their fee, despite the nature of the case and the complexities, they may not be willing, they may not be disposed at that position to make payment. It is now at the discretion of the ADR practitioner or the ADR institution to shift grants a little. And at other times, let me say this, if the ADR practitioner that has been appointed to manage that process, if he needs to make journeys to the place for physical sessions, the entire cost of his traveling will be involved in the process. But if it's going to be an online dispute resolution whereby parties will interface virtually, it therefore means that the cost will not include traveling. So it may be far cheaper than a physical session. Please permit me at this juncture to summarize by saying it is important for ADR practitioners to be transparent about their fees and discuss the structure with the parties before the matter begins. You don't disclose your fees midway. You must disclose upfront, and in most cases, payment is made before the session begins officially. Permit me to ask you, I hope I have been communicating. I hope I've been making sense.
Yes, sir. Very well, sir.
Yes, sir. Very well, sir.
Let me borrow the words of Maurice Bruce. I just want to make common sense. Thank you. Now, generally, some disputes are classified into monetary disputes. They have monetary claims. So you may make your filing fee, your process fee, and the amount in question, Thank you so much for your responses on the chat box. I appreciate you. You are remarkable. My mentor is here. Ambassador Victor Baba. It's nice having you join us. Thank you so much. We appreciate you, sir. Now, some matters are strictly monetary claims. It therefore means that the amount in question, the amount being claimed, will have an impact on the process. If the amount in the dispute is 10 million naira, the fee to be charged, you will know, will not be the same if the amount in dispute is just 1 million naira or 5 million naira. So the amount in the dispute goes a long way in determining the fees to be charged. So we have monetary claims, we have non-monetary claims. Non-monetary claims may involve maybe marital issues, communal issues, just name it. But let me say this, in most cases, based on the peculiarity of the ADR Institute, it may be a multi-door court. If it's a multi-door court, matters can be initiated at the multi-door court by private individuals walking in to the center. You call it walking matters. People can come in on their own. The multi-door court can also make what we call direct intervention. The multi-door court can also make direct interventions. Direct interventions, if there's a dispute between notable parties, economic disputes, the ADR Institute can decide to write and invite the parties so that they can make attempt in resolving the dispute. So you have walk-in, you have direct intervention, you also have court referred. Court referred talks about matters that have been referred from the court. Now, based on the civil procedure rules of the High Court, in Edo State Court, our civil procedure rules empowers the Chief Judge of Edo State, who also doubles as the Chairman, Governing Council of the Edo State Multi-Door Court, to refer matters from litigation to multi-door court at the point of filing or when the matter is already ongoing. It therefore means that parties can file a case in court instead of my Lord the Chief Judge assigning that matter to a High Court judge. At the point of filing, my Lord can refer that case to the multi-door court to undergo an appropriate ADR process. It therefore means that when it was being filed, they filed with the aim of litigation. In litigation, if you are looking for 1 million naira, you can file 100 million because my Lord will always use his discretion to beat it down. So most cases, when there are filings at the multi-door court, we look at it. These filings, were they made for the purpose of litigation or ADR? So while interfacing with the parties, there may be a need for them to refrain their processes for the purpose of making it appropriate for ADR. So it therefore means beyond their positions, beyond what they are asking for, during preliminary meetings, during pre-sessions, having understood what ADR is all about, they can have the opportunity to rephrase and recount their needs for the purpose of appropriate dispute resolution. And matters may already be ongoing at the High Court. It may get to a stage, a High Court judge may want to refer the matter for the purpose of ADR. At that point, the needs of the parties are usually considered. In summary, I'm saying that non-monetary matters may be simple, complex, or compound complex as it were.
The more complex it is, the more fee it will charge. If it's a monetary claim, the amount in dispute will determine what will be charged. In some jurisdictions, the fee being charged is fixed. If a matter is 4 months, 6 months, whenever it's been, no matter the lifespan of that matter, the fee charge is being fixed. In some jurisdictions, you pay the ADR practitioner per hour. So if it takes them 20 hours to resolve the issue, if that dispute has a lifespan of 20 hours, you multiply the rate per hour times 20. Some other jurisdiction is per day. So understand the uniqueness of your environment. We are saying so far in charging for ADRO services, the personality of the ADRO service provider, the nature of the case, what is obtainable in that jurisdiction goes a long way in determining what is being charged. Now, I may not need to bore you with this. A dispute resolution specialist is someone that has been trained and has gotten skills that will help him or her explore various ADR mechanisms in helping parties resolve their disputes. Now, I know we may have come across what we call ad hoc or institutionalized ADR services. Your fee to charge depends if you're an employee in an organization. If you're an employee in Shati, as it were, if you're working with Shati, if any dispute comes to Shati, Shati already has their scale of fee. So all you need to do is to look at the scale of fees and confirm under which category does this dispute fall into. So you cannot charge arbitrarily. You are confined to the procedures in that organization. But if the matter is brought to you as an independent ADR practitioner, then you cannot charge the parties based on your understanding of the process. So ADR services is either institutionalized or ad hoc. Institutionalized if the service is being rendered by an institution or an ADR center. Ad hoc if the service is being rendered as an individual. So as an ADR practitioner, you can practice independently. You can also be attached to an ADR institute in carrying out your services. Okay. We can make progress. The ad hoc when you are practicing on your own. You see, some medical doctors, they are attached to medical facilities. They may also have their private clinic where they run their services. Now, so generally, these fees being charged is usually mediation fee and professional fees. You also have administrative fees. Some high-profile mediators will tell you, this is the mediation fee for this dispute, and this is my professional fee. So it differs from person to person. Now, generally, to a lay market woman, the dynamics of cost is cost price, the transportation incurred, the expected profit you want to make, and any extra cost. When you add all of them together, you have your selling price. Now, it also applies to ADR services. All the costs involved, cost of transportation, maybe cost of feeding, cost of accommodation in case the service provider needs to transport the practitioner from point A to point B. Usually in ADR services, during sessions, parties are presented with light refreshment, soft drinks, maybe snacks, as the case may be, just to cool them down. The center may run some costs. Fueling, there's no way you can have an environment that is not befitting. All these put together usually determine the cost for session. Now, as we round off, Mr. Nathan
please, if I'm overshooting my time, please let me know. Permit me to quickly say this. You must understand your why as an ADR practitioner. Many persons were opportunity to be trained. You were trained on scholarship. You were trained, even those that use their own personal funds to get training. And at the end of it all, it stopped there. Many persons that were trained with me till date has not even pursued their dreams. Maybe they were not coined out for that. Why are you doing what you are doing? Why are you undergoing this training? Why do you want to become an ADR practitioner? We must answer this question. It is your why that determines your mindset and approach. You may be a wonderful and skillful dispute resolution specialist, but if you don't know your why, you may not be able to measure your impact and improve along your line of interest. Because as we all know, there are different spectrums of being an ADR practitioner. You may be a mediator, you may be an arbitrator. Even as a mediator, there are those that are specialized in family mediation. There are those specialized in communal mediation. There are those specialized in workplace mediation. There are different subcategories under mediation. The same thing goes for arbitration. So why do you want to become an ADR practitioner? When you know your why, you will be better prepared moving forward. It is your why that will help you identify what to do, who to tag along with, and when to do it. Is your why to make money? Is your why to help people? Is your why just to gain knowledge? But the truth is, if your why is to make money, you may not go far. If your why is to make people, you will get money. If your why is to seek knowledge, you will get money. That reminds me of the story of a woman that came outside her house one day and saw three men standing. One was labeled wealth, the other was labeled peace, the other was labeled long life. And she welcomed them into her home, and they said, we all cannot go in. Only one can go in. And she went in and called her husband. I told these three men to come in. They are strangers, but they said only one can come in. Who do we choose? Do we choose wealth? Do we choose peace? Do we choose long life? And after a long tussle between the man and his wife, they did an abridged mediation session, and they said to themselves, let us bring in peace. And they called peace, please come in. Your friend wealth and long life can stay outside. Now, while peace was moving, long life followed and wealth followed. And they asked, we only called peace. Why is it that both of you are coming? And wealth said, wherever peace is, I must be present. Long life said, wherever peace is, I must be present. It is good to talk about money, but if money is your only driving force for anything you want to engage in life, I'm sorry to say this, you may not go far. But when you want to help people, look at some of our renowned mentors that have made sacrifices to join us. Prof was with us yesterday, waking up so early in the morning. Mr. Victor Baba is on the call. Despite their tight schedule, they are seeing how best they can make impact into our lives, making us a better person. You won't tell me that life will have a unique way of repaying them back in a millionfold. So permit me to say this. We must have passion as our driving force. Your honest response will determine your line of action and will make a huge difference in your career. Your Excellencies, permit me to say this. There's something I want to project. All right. Now, whether there's a need for a special skill or service in the process, the cost value or importance of the subject matter, the result you obtain. I have said, and please permit me to interact. You don't charge fees because of the outcome. You charge based on the process. ADRO provides a platform that no other feed can provide. It gives party the ability to move on. It gives party the ability to determine the outcome. You charge for the process and not the outcome. You are not a magician. I was once in a session and parties were asking, why should we pay? What if you are unable to resolve the matter? And I said to him, with all due respect, sir, I want to appreciate you for the confidence you have that I should be able to resolve this dispute. But can I shock you? I don't think I will be able to resolve this dispute if you are unwilling to resolve it. The man looked at me and smiled. A very senior legal practitioner. I said to him, you do not resolve. It's at your instance. If you wish to resolve this matter, it will be a jolly good ride. But if you do not wish to resolve this matter, we cannot compel you. In a particular session, one party was just arrogant. And while he was speaking, I kept mute. I was looking at him. I was nodding. I was smiling. He was talking. I was smiling. When he was done, I called his name and said, thank you so much, sir. I believe that you needed to let go that thing so that we can make progress as far as this issue is concerned. I want to appreciate you because to me, you are a very brilliant and intelligent man. And I know because you are here, we can move forward. Everybody was stunned looking at me. You don't need to take offense because you may just need to pamper their ego to enable them move forward because we have different personality types. When you understand the dynamisms in human behavior, you should be able to make significant progress. All right, these are different. Okay, I don't think this is within the scope of our lecture. All right, let me just move to my next slide. I hope I'm making common sense, please.
Yes, sir.
Thank you.
You're making sense, sir.
You must understand that you must invest in trainings. You must develop your act continuously. You must learn continuously. Take advantage of local trainings.
Round up now.
Thank you so much. Volunteer. I'm glad Shati has a very robust platform. You can reach out to Mr. Nachan, the husband of one female wife, and tell him, sir, is there an opportunity to volunteer? I have these skills. I'm an IT person. I'm into writing. I'm into editing. I'm into programming. These are my skills. How can I add value to Shati? And I'm sure you'll be welcome. Now, finally, creatively define and design your style. Two persons can never be the same. You cannot be like every other person. Clearly and creatively define your style, design your style, and hone your skills. Thank you so much. How do we make money? You can make money when you mediate on cases as a mediator or when you arbitrate matters. You can also make money by representing your clients, becoming a mediation advocate or a mediation advisor. You can make money. Actually, in mediation, lawyers do not have the training to add value to the process. They have training to litigate. Lawyers that have not undergone ADR training do not have the skill to add value to ADR processes. Those that are the way lawyers make representation for clients in court. That is how mediation advocates or mediation advisors make representation for parties in a mediation setting. Lawyers that have been trained as ADR experts are known as mediation advocates. Non-lawyers are known as mediation advisors. They are the ones that make representation. So the same way you get your appearance fee when you appear in court, you also get your fee. You can charge professionally on ADR matters. You can become a consultant. Somebody gives you a call, I have this dispute, what do I do?
with your knowledge, you can advise the person on which of the spectrums to undertake. You are giving consultancy services. A lawyer came to my office one day and was talking, and I did some explanations to him, and I said, hope you know this is consultancy. They started laughing. You put it to them. Facilitation training, when you engage in facilitation, when you engage in training, you get remuneration, and that becomes a plus to you. Beyond all of these, the scope is endless. Let me appreciate you for giving me your time, your ears, your attention, and I hope I have made common sense as far as charging for ADR services is concerned. Thank you so much.
Thank you, sir. Thank you, sir.
That's your question.
Thank you very much, sir, for that wonderful session. We appreciate you.
Thank you, sir.
Thank
and
you.
I appreciate you on behalf of the management and of Settlement House ADR Training Institute. We appreciate you for that wonderful and well-delivered session. Thank you so much. If you have questions, drop it on the chat box. Mr. Victor, please, sorry, the session is long. We had to see how we can cut down one or two things in order to accommodate the reshufflement and adjustment in the time. Mr. Victor, sir, are you with us?
Good afternoon to you and good morning to those of us joining from different geographical locations.
Thank you very much, sir. We appreciate you. Thank you. Thank you. So if you have any question, you can drop it on the chat box. Mr. Victor and Mr. Samuel will be here to attend to your questions. Drop it on the chat box while we call on hand over to Mr. Victor. Sorry for waking you this early again. We hope that the network and everything will be fine today. Thank you and happy new month.
Happy new month to you and to everyone. Once more again, good morning, good afternoon, good evening.
You're welcome,
depending
sir.
on where you're joining us from. Can I appreciate my friend, Reverend Samuel, for the incredible work. It's always good to
Very
see
good
and
morning,
to hear
sir.
him.
Happy New Month.
Happy new month to all of you. With your permission, Mr. Nanchang, am I allowed to, take the reins of the floor?
Well, sir. Over to
All
you.
right, thank you so much. For the next 45 minutes, I want to crave your indulgence. And then maybe for the last 15 minutes, we'll get to have my mentor. My mentor is here with me. So at some point, I'm going to ask him to come and speak to you people. My mentor is Judge Danny Weinstein, one of the most renowned and distinguished mediators across the universe. So at some point, he will just appear to say hi. But with that said and done, our discourse for the day is culture and mediation, or culture in mediation. And this is just a condensation of
Thank you very
what
much, sir,
culture...
for bringing him in. Please, if we need to create a little time for him to speak to us, we really appreciate it. So I believe that I have the consent of the participants to have some little time extension. If you are with me, you need to give me a thumbs up. Participants, you are privileged to have one of the distinguished ADR practitioner in the world join the training to say one or two things to you. I believe I have your consent. I'm talking to the participants. Can you hear me?
Yes, sir. We can hear you, sir.
Yes, sir. We can hear you, sir.
I believe I have your consent to have some
Yes, sir.
extension so that you can
Yes, sir.
benefit from the wealth of experience of this distinguished a mentor to your trainer and mentor. I think it's actually a privilege to tap from
A privilege, sir.
their experience. Thank you very much. Thank you,
Thank
Mr.
you, sir.
All right. So for the next 45 minutes, I want to talk on culture and mediation. And just like I highlighted earlier on, this is a condensation. It's, it's a brief summary of the possibilities of the interaction between culture and mediation. And for the next 45 minutes, I'm going to crave your indulgence. And please, when I ask a question, if you want to respond, you can always respond. So with that said and done, let's look at culture and mediation. And for our discourse today, we have 4 questions that will govern and influence how our proceeding goes. And the 4 questions are as follows. What is culture? Then number 2, what are the manifestations of culture in our everyday lives, in our geographic locations, and at our various workplaces, or at your faith institutions? If you go to church, if you're a Muslim, if you every other Friday get the opportunity to go and exercise your faith at your mosque, how does culture find expressions within that context? And then number 3, we'll get to look at how does culture interface with mediation. And then last but not least, hopefully we'll get to look at how to navigate cultural complexities. Sometimes navigating culture is like peeling an onion. And when you're peeling an onion has layers over the other. And so sometimes it can really be difficult to entangle some of the cultural complexities that are likely to find expression within dispute resolution, mediation to be specific. And then hopefully last we'll get to have discussions maybe for 5 minutes. And I'm hoping that my mentor, who is a mediator's mediator, Judge Danny Winston, will be able to appear and speak to us 1 or 2 things. And thank you once more again, my good friend, Mr. Nanchang, and by extension to each and every one of you of giving us the permission to have him appear and speak to us. All right, with that said and done. Oh. Okay, my screen is not, let me try and redo it again. So what's culture? That's a good question to each and every one of us. And maybe as I try to get my slides, can somebody tell me what they understand by culture?
Culture is a people's way of life.
Wow. Wow. And who is that? Let me know your name and let me get to see
My
your
name
face.
is Cordina. Cordina,
Wow.
Kodinna, sir.
Wow. Thank you so much. That's a beautiful response to our subject matter for the day. It's a way of life, which I find to be very beautiful. It's a profound and deep statement. And thank you for that. Anybody else would like to take a look at what culture is?
I'll say culture is people's set of beliefs, their custom, their norms, and what they actually believe in. Their set of rules and their regulations and their norms. That's what makes their cultural whatever.
Wow. Thank you so much. I love that. Anybody else? I was just writing down as you were speaking. You said that culture is customs. There could be norms. There could be rules and regulations. Beautiful. Anybody else? Anybody else who wants to
Culture
attempt?
Culture can be
Sure,
defined as a value system of a group of persons. So what
Wow.
they value, they have come to accept as binding on them to be
Wow.
stemmed their culture.
Wow. Oh, beautiful. Thank you so much. Anybody else? Value system. I love it.
Yes, my name is Gloria Jude. Culture in a very simplest term, the way people do their things, the way they eat, the way they dress, the way they even talk, the way they agree to do things generally. So that's in a very simplest terms. Thank you.
Wow, thank you, Gloria. Beautiful. How they eat, dress, talk, etc. Wow, this is beautiful. I'm just jotting down as you guys are speaking.
It could
Anybody
also
else?
mean, yes, it could also mean their acceptable traditions and beliefs.
Beautiful.
Acceptable traditions and
Traditions
beliefs.
and beliefs. Wow.
Yes.
This is pretty interesting. And thank you so much. I love your voice. Anybody else? Anybody else before?
Culture is a way of life of a particular set of people acceptable to them.
Wow. It's a way of life. Beautiful. Acceptable to them. Thank you. Wow. Anybody else before we close this window of opportunity? Or forever hold your peace? I'm just kidding. I'm just kidding. Anybody else who wants to bring to our attention what they perceive of culture? And while we're doing that, we've got an image on my screen. Let me know if you can see my screen. Kindly let me know if you can see my screen.
Yes, we can, sir.
Yes, sir. Very
All right,
clear.
thank you.
Your
Thank
screen
you.
is clear, sir.
All right, thank you so much. Beautiful. Okay. You've told me what culture is, and I like your thoughts. I have to confess, I like your thoughts. I like how you people are thinking. And I think this is the right group. This is the right group. Yes, we can see you. All right, thank you. All right, we've got an image on our screen. If you've got a visual of my screen, we've got an image. And I don't know what you guys think. So in the next 2 minutes, just you can write on the chat, or you can voice, you can vocalize your thoughts. You know, what are you seeing on the screen?
Tea culture.
Tea
All right.
culture.
All right. But thank you for that. What else can you see?
A man with a teacup in front of him.
Right. So we've got about 3 gentlemen. I'm so sorry that the image is not clear, but we've got 3 gentlemen, and these 3 gentlemen are generation apart. It's not so clear, but this is a tea table, and we have 3 gentlemen, and we've got 2 gentlemen. The ones facing you, they belong to one generation, and the man facing them belongs to another generation. And if I were to, they say a picture is worth 1,000 words, right? So it's more than a tea culture here. If you were to ask me what's going on here, I'll tell you that these are men discussing pertinent social issues within their given society. This could be men negotiating bride price. This could be men trying to resolve a boundary dispute, because there's such a thing as tea culture, particularly within the Somali group that is based in the East African community. Tea culture is such a powerful thing amongst the Somali people. I'm led to understand that amongst the Chinese, tea culture is, or the Asian community to be specific, we've got the tea culture, and it signifies a lot. For instance, in the Chinese culture, I'm led to understand that before a Chinese can actually transact with you commercially, you've got to take a ritual of a tea kind of a ceremony. And in this tea kind of a ceremony, they try to honor you as a person. They try to see your value system, and so on and so to speak. So there's power in culture, and this is what we're seeing here. Earlier on, somebody said that culture is equivalent to our value system. Somebody said that it appears in how we eat, what we eat, how we dress, how we talk, and so on and so to speak. And at this point in time, I'm going to make an assumption that culture influences our identity. So culture is identity. I don't know what you people think about that, but culture influences our personality. And that's very important. Culture is our identity. Usually when I am speaking to a large group of people, I always talk about where are you coming from? And where you're coming from is not to locate your geography. It's to locate your heritage and your culture, or your root system. So culture in so many ways is a rooting system for so many of us particularly within the African societal fabric. And so culture is very important. And with this, I'd like us to take we've already seen, what culture is. I'd like us to take a deep dive at what culture is, and maybe we'll get to classify. So what happens after, okay, I'm still seeing questions on our chat box, but we'll get to have a look at our questions later on. So we'll get to look at, how culture manifests in our society or in our world today. And maybe we'll get to classify culture into three categories. They could be more categories, but for today, we'll look at culture from a national or a geographic standpoint. Then we'll get to look at culture from an organizational standpoint. And an organization here simply could mean your place of work. It could mean where you go to church, where you go to mosque. It could mean how your market is arranged, and so on and so to speak. So what's culture? That was our question, and somebody said that culture is a way of life, which I think is beautiful, and I don't think we can go beyond that. It's the most remarkable and shortest explicit response to what culture is when we all think about that. So it's how we live, and it's a pattern of thinking. Culture shapes our thinking, it shapes our preferences, and most likely it shapes, what we eat, how we dress, and so on and so to speak. And culture is multifaceted or multidimensional in so many ways. Earlier on, I said that sometimes entangling culture is like peeling the proverbial onions, and onions is good. If any one of us, those of us here who are fond of cooking are fully aware of the fact that onions have layers on top of one another, and sometimes that's how culture can be. So it's multifaceted and multidimensional, and culture can be national culture, what we have in geographies. You can talk about Nigerian culture, you can talk about African culture, you can talk about the Western culture, you can talk about the culture of the Igbo people, right? There's a culture in North Nigeria, and there's a culture in southern Nigeria, and so on and so to speak. So culture can be, it can be understood from a geographic kind of a location, and that's why we have national culture. Again, we've got organizational attitudes or organizational culture. When you think of your when you think of your workplace, when you think of your business, when you think of the corporate world in Nigeria, some of the companies and so on and so to speak, discipline. And here, when you think of culture from an organizational standpoint, it's the total sum of routines within a given environmental context. And then last but not least, we've got individual culture. And this is where identity is very important. That culture is it has an intimate relationship to our identity. Our identity is influenced by our culture, and our identity influences our culture. So here, I mean, when I speak or talk about individual culture, I'm talking about the routines or rituals of a person. Now, myself, before I get to sleep, I have a ritual, and that's praying on my knees, and that has become my culture in so many ways. Or even when I wake up early in the morning, I always go down on my knees and I get to pray. And in that sense, prayer has become my culture, or faith has become a culture to me, because this is a cultural practice that I get to do every other day. And I intend and plan to keep that a culture for the rest of my life, because I know the benefits. And at this point in time, maybe allow me to say this, that culture has its own benefits. And sometimes it has its own limitations as well. Remember earlier on I said that a culture is a pattern of thinking. And in so many ways, sometimes our thinking can be the very platform or launching pad of how much we can achieve in life. And sometimes it can be the very prison that limits how far we can go or excel in life. So that's very important. And culture creates expectations. Somebody said that culture is a way of life. It creates expectations. When you view culture as a set of traditions, what traditions do is create expectations, societal expectations, and sometimes individual expectations or responsibilities and roles within our societal environment. And with that, I'd like us to look at how culture manifests in our everyday life. How culture manifests in our everyday life. So here we've got an image of a plant, and the plant has got a rooting system. I don't know if you guys can see it, but anyway, we've got a diagram of a tree here. The tree has got a root system. The tree has got a stem and it's got leaves. And sometimes culture can be connoted to be the root system of a tree. We don't see the root of a tree, but definitely we see the fruits of a tree. We can see the leaves, we can see the branches, we can see the stem, and so on and so to speak. And sometimes that's how culture can be subtle, it can be nuanced, and it can be invisible yet very palpable and tangible. And with this in mind, I'd like us to look at the various ways that our cultures find expression in our everyday life. And please allow me to confess that this is not an exhaustive list of how culture manifests in our everyday life. Earlier on, I issued out a disclaimer that our discourse today is all but a condensation of a broader conversation that maybe next time, if we get to have enough time, we'll get to have a look at. So beliefs. All too often, our cultures will find expression through our beliefs. And what are our beliefs? That's a good question. Beliefs here could be our thinking patterns or thoughts. It could be our it could be our reflections and introspection and so to speak. And that brings us to organizational attitudes. Sometimes you just need to interact with an individual working at a particular place for you to understand the cultural fabric of that place. Or you just need to interact with one worshiper. If we are talking about a faith-based institution, you just need to interact with one worshiper, and you will get to have a window of opportunity on the cultural practices of that particular faith-based institution. And it could be faith, prayers. I mean, on Fridays, Muslims at some point, they close their businesses and they go to their place of praying. And that's culture. That's culture. Somebody said earlier on that these are ethics, right? I agree with you. Virtues, they are routines. Somebody said culture is how we eat, what we eat, when we eat, and so on and so to speak. So food is a great manifestation of our culture at the end of the day. Our dress code, and earlier on somebody brought that to our attention. Identity, which I think I have on numerous accounts made a mention of that. Tradition, somebody earlier on spoke of traditions. Now, I don't know, what do you think is missing on our list of manifestations of culture before we proceed to the next slide? Anybody else? You can write it on the chat, or you can vocalize your thought. In what other ways do our cultures manifest or find expression in our everyday life? All right. Oh my, beautiful. Thank you, Chioma. Music. Wow. Wow, that's beautiful. And that has just provoked a thought in me. Thank you for that. Art. I mean, think of art. Just think of art. What we're seeing here, this is art. Pardon?
Religion.
Our religion is faith. Thank you for that. Anybody else? Anybody else before we proceed to... Oh, accent. Thank you. Language. Thank you, Josh. Language. All right. Language. Thank you, Glory. Thank you. Anybody else? In what other ways does our culture appear on our everyday life?
Gesture.
Oh, wow. Gesture. Beautiful. Very nuanced. Thank you. Beautiful.
Greetings, the way we greet.
Oh, beautiful. Thank you. Oh, how we honor people. Oh, yeah, taboos. Thank you. That's a good one, taboos. Oh, poetry. Wow. Thank you. Tribal marks. Oh, wow. That's a good one. That's a good one. That's a good one. I'm almost tempted to belabor on this, but I'll proceed to our next slide, which is how does culture interface with mediation? So culture, people have different ways of connection and trust. And yesterday we made a mention of the significance of connection and trust in mediation when we talked about your opening statement. Right? Building connection and trust. This is very important. In certain cultures, before I can trust you or before you can trust me, we need to sit down and have a cup of tea. Or we need to sit down and eat as a pre-ritual to transacting or interacting with you. So this is very important. How people build connection and trust varies from one culture to another culture. It could be gifts. I mean, think of gifts. Think of gifts. And think about the 5 languages of love. The 5 languages of love. Giving is one of the most important language of love. So there are people who give gifts as a sign of connection and trust. And that brings us to our second fundamental point. Culture impacts communication. Earlier on, we spoke about language. Culture has, culture has this beautiful way of affecting our languages, how we greet people. Very important. There are certain cultures where, putting your hands together as I'm doing is a show of respect. It's a show of honor. It's a show of greetings. It's a show of peace and so on and so to speak. Just like I'm holding my hands right now. Or think of a handshake. Think of a handshake in a business environment. Think of a handshake in a diplomatic environment where you have 2 diplomats shaking their hands. And without getting deeper into the science of handshakes, there's an assumption that when somebody extends a handshake to you, it's a gesture of goodwill. And somebody earlier on mentioned that gestures they appear in our everyday lives. So sometimes a handshake, a firm handshake, is a gesture of good faith. A handshake could equally mean pardon? Hello? Sometimes a handshake could signify that I don't have a weapon. I'm not holding any weapon. And we see this in our everyday lives, right? Without belaboring on that point, I want to say that culture can influence our identity. And at this point in time, I'd like to introduce you to a hypothesis that has been put together by one of the most remarkable mediators right now in the world, Professor Suksim Ranj Singh. You can look him out after we're done, or I'll write his names down here. He's one of the voices when it comes to culture and mediation. And one of his hypotheses is that culture can be labeled into 2 groups. We've got collectivist culture. vis-a-vis individualistic culture. And a collectivist culture, in simple language, refers to group thinking. Now, earlier on, we mentioned that culture is a way of thinking. It's a thinking pattern. And within the framework of culture being collective in character, we are referring to a group of people. And this is predominantly within the African societal fabric. We think as a group. And therefore, consensus building becomes very important. Before I get to travel, I always need to let my father know that, you know what, that there's this trip coming and I need to travel. What are your views? That's group thinking. In the African fabric, before you can purchase a house, you often consult certain people around you, and they do not necessarily need to be your parents. This could be men of faith that you have submitted unto. And therefore, consultation becomes important. And so when we look at culture from a collectivist perspective, there are certain concepts that come to mind: consensus building, collective decision making, consultation, and so on and so to speak. And then on the other side of the coin, we've got individualistic societies. And in so many ways, the Western world has been characterized through the lens of individual, they think as individuals. And that has its own merits and demerits. So decision-making is quick as compared to our African society, where you have to consult many other actors or many other stakeholders that hold influence over your life. Again, in individualistic societies, when it comes to commercial transactions, you don't need to consult with your father, your mom, and so on and so to speak. And sometimes in commercial disputes, this culture finds expression predominantly through these kind of lenses, from a collectivist society perspective and from an individualistic perspective. And let me get a thumbs up if you guys are following if you guys are following our proceedings. Let me get a thumbs up. Or let me get some signs of life. Just, you can give me a thumbs up, or you can say I follow before I move further. And I'm very conscious of our time. All right, Raji, thank you. Thank you for that thumbs up. So culture often has a consequence on responsibility, money, and commitments. Earlier on, I said that culture creates expectations or burdens. There are burdens that come with our culture. And I use burden here in a positive note and on a negative sense as well. Cultures create expectations and burdens, responsibilities. In the African culture, for instance, if you are the firstborn, and I don't know if we have firstborns here, culture places such a burden on you, the firstborn. You are not just born the first. There are responsibilities that are tied to being a firstborn. And I speak as one. Culture has placed certain...
Yes.
Pardon?
I said yes, as a pastor. Culture has placed so much on us.
That's right. There are burdens that we carry as firstborns. And this is because of culture. And in the context of mediation, sometimes responsibility. So if a firstborn is negotiating, they don't just negotiate on their individual capacity. They are negotiating bearing in mind that they have other individuals who are following them. So that's the significance of a culture through the interface of mediation. Money. In the African fabric again, our perception or our assumptions around money have got to do with culture. And I'll use an example of myself. I grew up in a home where conversations around money are extremely uncommon. And so every time when I am just about to get into an activity, money is often secondary. It's not the first priority. And in so many ways, this can be traced to my culture, corporate culture, and the family culture, cultural context where I grew up. And sometimes in mediation, there are individuals who see money as a priority, and therefore they will place a high premium or precedence over monetary considerations. That's how culture finds expression. And sometimes there are disputes where money is secondary. And a good question here is, secondary to what? Secondary to what other considerations? Other considerations could be honor. There are societies, for instance, the African society and the Asian societies, where honor takes precedence over money, monetary commitments, or compensation. Think of reparation, think of apology, and so on and so to speak. Again, culture can influence commitments. To what extent are individuals willing to commit to a negotiated agreement that has just been sealed through a mediation proceeding? And then last but not least, language is a fundamental aspect of culture, not language. I'm sorry for this typo here. Language is a fundamental aspect of mediation. There are instances where you'll be mediating between groups that speak different languages. And at some point in time, you want to duly consider that. So the use of interpreters. Earlier on, we mentioned that culture is language, or culture finds expression through our languages. So this is very important. And sometimes translating from one language to another language creates its own subtleties and nuances. And so it's always important to be alive and to look out for that. And at this point in time, I'd like us to look at how do we navigate culture in mediation? How do we navigate culture in mediation? One, I often talk about cultivating an executive presence. I use that word cultivating very intentional and deliberate, because it's something that is not gradual. It's not over. It's not over the night. It takes time for you to cultivate your executive presence. And I know somebody is asking a question, what's an executive presence? And in a simple way, an executive presence is an amalgamation of various qualities and attributes that make you stand out as a mediator, that makes you become inspirational, influential, and a transformative leader. If we had time, I would have taken time to talk about the interface between leadership and mediation, because that often influences what an executive presence is. And the difficult thing about executive presence is that, number one, it takes time. It's extremely personal and intimate. And so you need to invest time. You need to invest time into practice to cultivate your executive presence, because it's something that is extremely personal. It's customized. And it takes time, as I have mentioned earlier on. So sometimes it's extremely difficult to put words to what an executive presence is. But if I was to use other synonymous words, that would be aura. There's an aura of a mediator, and there's a good book that maybe I'd like to recommend to each and every one of us. The book is called Bringing Peace into the Room: How the Personal Qualities of the Mediator Influence the Process. I'm going to say that again. bringing peace into the room, how the personal qualities of the mediator influences the process. And at this point in time, I know most of you understand the multifaceted process that mediation is. And I want to throw these at all of us. Our personal attributes all too often will influence how the process goes, or our personality is likely to have a significant ramification on the process of mediation. Now, without belaboring on what an executive presence is, I'd like to proceed to our second strategy for navigating cultural context in mediation, cultural diversity quotient. At this point in time, I'm fully aware that we've had a look at emotional intelligence, and I want to present or submit to all of you that there is such a thing as cultural intelligence, the ability to navigate within cultures without losing your own culture. And how do we become competent or intelligent cultural beings? One of the virtues and values that comes to mind is humility. It's humility. Without humility, we cannot learn and discover new things. And sometimes for you to be culturally competent, it takes a great deal of learning. And without learning, without humility, learning is almost rendered impossible. So in so many ways, the secret sauce or the secret soup to becoming culturally intelligent is always being humble, humility, and being sincere, and so on and so to speak. And that brings us to listening. Yesterday, we spoke at a great length on what listening is all about. And I remember I recommended a book, Just Listen, a powerful book that, again, I want to stress or underscore that you need to get a copy of it. There's an audio and there's a hard copy and there's a soft copy. So you've got a wide array of options when it comes to that. And I think so far I have recommended two books to all of us. Just Listen. The other book is Bringing Peace into the Mediation Room, how the personal qualities of the mediator influences the process. The book has an entire chapter on how to cultivate and build an executive summary. The hypothesis of the book in simple terms is the idea that mediation is a calling. Mediation is more than a profession. It's a calling, and it's a calling to change the world. That's how beautiful the book is. And then building a connection and trust with parties, right? Sometimes if you don't understand where the parties are coming from, it's going to be extremely difficult for you to connect and trust with the parties. And earlier on, we said that culture is a way of life. You don't want to disregard, or you don't want to overlook, you don't want to trample on other people's way of viewing life. And in that sense, if you are striving to build a connection and trust with the parties, it's going to be important for you not to disregard their culture, honor their culture, and honor who they are, because often culture is who we are as a person. That's very important. And then last but not least, the use of interpreters in the event of language barrier. Translation has got its own merits and demerits that I don't want to get into. So that's how we navigate cultural issues within the context of mediation. And at this point in time, I'd like to invite questions and answers, and maybe we can get into some kind of discussions. And our question here to lead our discussion is, how do we become culturally intelligent? So at this point in time, I'd like to invite your questions. If you have comments, better yet, if you have compliments, that would really be appreciated. And I'm aware I made a promise earlier on that at some point, my mentor, Jadani, will be making an appearance. So do we have any questions before I can call him? Any questions?
Sorry, sir.
Sure.
Even though I was on and off during the class, but I tried to, put culture and mediation together and see how a mediator will try to strike in a balance in between disputes that are traditionally inclined, and at the same time, the other parties are not in support of those cultures or traditions. How can a mediator come in between of such scenarios?
Wow, beautiful. Thank you for your question. Sometimes the parties do not have an understanding of what mediation is all about. And that's why yesterday, in our opening statement, we said that one of the functions of an opening statement is building the capacities of the parties to fully comprehend what mediation is all about and how to participate. So empowerment, and by empowerment here, I am referring to education. We have a responsibility as mediators, as neutral parties, to educate the parties on certain things that are very significant. And all too often, we are agents of conscience to the party sometimes. When we feel a party is derailing or getting off track, we have a responsibility to bring them right on track. That would be my response to your question. Or for instance, when in our African culture, for instance, when a young man is negotiating or is in a dispute with an elderly man, definitely you are going to have some sense of cultural expressions. Because in our African culture, we've been taught how to have regard for the elderly, and so on and so to speak.
Yes, sir.
Right? Or greetings. I mean, there are certain cultures, a young person has to bow down before an elderly person, or a young person needs to kiss, the legs of an elderly person. And in certain cultures, that can come off as bad. But they need to find a way to stomach that and work with that. So that's how culture is very important. Myself, when I'm having discussions with my father, I don't sit down. I stand up.
Okay.
Right? As a show of honor, as a show of respect. So honor and respect are fundamental in our human interactions, and so in mediation.
Thank you so much, sir.
Thank you as well. Anybody else? Anybody else? Right? And we have a beautiful question here. How do we become culturally intelligent? I would want to know your views.
Well, one way of becoming culturally intelligent is that we must learn the culture of the people, try to know it, and why do they practice such culture? Why is it dear to them? So when you know it, then you'll be able to key in and to be at home with the culture.
Wow. Wow, beautiful. And thank you for that. And we live, we are increasingly living in a world that is becoming globalized. And therefore cultural intelligence is going to be significant, not just for us mediators, but for every other human being, because we are, we are beginning to we live in a world that is becoming culturally stratified and diverse. So it's something that we need to work on. All right, reading about other people's culture, that's beautiful. Acceptance and open-minded, beautiful. Thank you for your comments. Mr. Nanchang, are you here?
Yes, sir.
All right. I'd like you maybe to take steer of these proceedings as I try to get hold of Judge Daniel Weinstein. You can steer the conversation on how to become culturally intelligent as I try to look for Judge Daniel Weinstein. All right. This might just take maybe 1 minute and then I'll be back. Thank you.
All right, thank you. All right, so let's speak. So I will just point, Augustine Chima, can you tell us how one can become culturally intelligent? When you finish, Raji will speak. Go ahead. Mr. Chima.
Sir, can you hear me?
Yes, sir.
Sorry, I didn't get the question straight. I didn't get it right.
How do you become culturally intelligent? How?
Okay. I would say by adapting to other people's culture, not just your own that you practice, but being open-minded to accommodate other people's culture. I think with that, one can be culturally intelligent.
Okay, you know that we have Igbos, Yoruba, Hausa, different culture in Nigeria. And
yes, sir.
All of them behave in different ways in certain circumstances, right? So
Yes, sir.
as a Nigerian, how do you become sensitive? And now you are being trained to become a mediator. Let's say in a someone gave us an example, in a mediation session, there was this colonel in the army, and then she has made a lot of effort to reach out to him. And then when eventually he came for the session, she stood up to greet him while the other person was, the other party was sitting. And that became an issue. In fact, he said, oh, so you even show more respect to this person, you are even standing up for him. You didn't do the same to me. So I don't believe that this is going to work. So he walks away, and that was the end of the session. So the issue of culture is very, very sensitive. We have seen cultures, for example, where when someone dies, they take flowers. But when you go to another culture, when they are bringing flowers, what does it connote?
Okay, from the last instance that you gave,
Yes.
to some places, when they are burying someone, they take flower. Like I think in outside Nigeria, they take flowers, they keep it at the gravesite. But then over here, you find it difficult to see people going with flowers. And let's say, okay, on the second instance of the corner own, I think if I'm a mediator at that point, when I'm trying to drive it down to culture in my place, if the culture is that when you see an elderly person in a position, you stand up to greet, and then in the other person's culture, you stand up to greet everybody regardless of their position. And if I want to know if your last thing was a question. as to
give
what will
you
I
an
do.
example of how sensitive, our attitude towards culture will affect what we do. And we are discussing on how do we become culturally intelligent, So these are some of the things that we are looking at. And that's why I said, how does it become? Okay, oh, great.
Can I give an example?
Okay,
Mr.
let's
Nanchang.
listen to Mr. Victor. Can you kindly make an introduction and then he takes over before other comments?
All right. So our beautiful class we have here with me, Daniel Weinstein. He's one of the most globally renowned mediators across the world. His work speaks for himself. He's done it for the last 30 years and so on and so to speak. And he's done mediation across the world and across various cultures. And I am privileged to have him as my mentor and as my personal friend. And today he has, carved out a few minutes just to come and say hi and maybe say one or two things about culture. And then maybe we can take 3 or 2 questions and then we can call it a day. So back to you, Mr. Nanchang.
You're welcome, sir.
Thank you very much. Thank you very much, sir. We are honored to have you. We have heard of you and we have heard of the work that you've been doing. And we're very proud of you and we're very honored to have you. Please, over to you, sir.
Well, thank you. I can tell you that I'm honored to be here, although Victor told me I should put a tie on, and we're down in Mexico at the beach, and I'm dressed up as well as I can. But I have a special place in my heart for Nigeria. We a couple of our outstanding Aminu, who was one of our early fellows in our foundation, of which I'm proud to say that Victor has become one of the stars of promoting mediation and especially cultural dynamics throughout the world. And of course, Banki, I forget her
Victoria Banki.
Victoria Banki is
from Endo State.
From Endo State, okay. And she's terrific also, and she, I spent some memorable times with her in mediations. But you all are doing something very important. What those of us who were the early pioneers in mediation and had both the excitement, adventure, and the disappointments of trying to take it to different, first of all in the United States, and then began the process of trying to sort of adapt mediation to different cultures. And it was both exciting and challenging. We worked with the chief judge in Bhutan, who took it out to the little tribal villages in the mountains and tried to make mediation consistent with their tribal customs. We worked with 5 different mediators in China, all from different regions where the cultures were so different that you had to approach them, even though they're from the same country, very differently. And I learned in my mediations through a lot of good lessons, how important it was to understand culture and how people in culture have been trained and acculturized to deal with conflict, to deal with negotiations, how differently doing, for instance, a mediation between Japanese and Chinese, you think, well, they'd be the same. Not at all. Completely differently, the way they negotiate, how they look at negotiations, and so on. And so even within a country such as Nigeria, a large country with many different tribal inputs different cultures. There are very different ways in which people resolve conflict. And you have with you some of the best teachers and about it. And it's something that I hope you as students, and then I'm going to be quiet and take your questions, but I hope as students you get excited about, because many of us who've been trying to do negotiations for many years realized that sometimes it didn't work because we were, even though people might come from the same area, it was just, we were talking different languages. We were talking about different ways of, some people negotiate very openly and frankly. Other people are trained to be hidden and cautious and all of that. So we as peacemakers, as mediators, have to be aware of what those cultural nuances are and respond to them in mediations that way. Is because it doesn't have fixed rules. Because unlike the courtroom where you stand here and you follow rule 14C, and some judge is telling you do it this way, in mediation we go with whatever works. We use our imaginations and creativity, and we just follow the two sacred rules that it's confidential and safe, and it's voluntary. In the end, people have to agree. No one tells them what to do. And so within that, culture and being attuned to culture is so important. And you should be excited about it, because when you hear how important understanding culture and the way people negotiate are to the success of getting a deal, you'll realize that it's a wonderful tool to have. And you have, I know in Victor, and from what I've heard of your professor there, that you have some of the best people teaching you about it. So I'm just a beach bum down in Mexico right now, but I'll sure take a couple quick questions if anybody has them and wants to ask me, and I'll do my best to answer. But I'm honored to be part of your class, and I look forward someday to visiting you. When we first started the foundation, and Aminu was a member of our fellows, we explored a project of bringing mediation practices out to the police stations in the desert and in distant regions where a lot of the justice was done, and to see whether or not mediation would be an effective tool even for law enforcement agents. And we've had some great success in Pakistan and other countries with taking mediation out into areas of law enforcement, just as an example. Okay.
Thank you very much for the privilege of having you on this particular training. I believe that our participants are greatly honored to have you. I actually applied for the fellowship of Winston Foundation.
Oh,
but unfortunately, we have too many people who are qualified, and we will keep trying. We are aware of the work that you do, and we are hoping.
Well, I hope you apply again, and with Victor's recommendation, you may you'll go a long way. We'd love to have you.
Yes, thank you.
Are there any questions quickly? Otherwise, I'll turn it back to Victor and into your capable hands.
I have a
All
question.
right, thank you very much. Please if you have any question, put on your camera and be free to speak. And Mr. Weston is here to attempt your question. Thank you.
Okay, I have a question.
Good evening.
I can't see your face. You're it's covering that. There
Good
you go.
evening.
Now
I
I
have
can
a
see it.
question.
Thank you. Hey, would you introduce? Please
Okay.
introduce yourself.
Okay,
Kindly
okay, go
introduce yourself, where you're calling from, and then ask your question.
I see. Okay. Thank you.
My name is Anita. I'm calling from Maryland. And my question is, if you have people from different cultures who don't understand the situation, like in my culture, when you invite me out for a birthday party, maybe at a buffet, the host who invited me is supposed to pay for me and maybe the whole people that were invited. However, in another thing, they are thinking you have to pay. So if you are there and somebody invites you, oh, it's my birthday, I'm inviting you, let's go and eat here or there, and you go, that means that you are supposed to pay for yourself. However, if you are from a culture that you are used to the host paying for for you, then there is a conflict. And so when these people come together and there is a conflict that no, I didn't tell you to invite me, you invited me, so you have to pay for me. And the other culture is like, that is the norm here. When we invite you, you are supposed to pay for yourself. And there is this misunderstanding. And if you are in like a mediation like that, what do you do?
I put it all on Victor's MasterCard or on his Visa card, and just charge it to him. No. These are the little problems that good mediators are able to overcome by perhaps just everybody's there and they've done it and just say, look, let's do the mediation first and see if we can get something solved and then deal with the money problems afterward. And there are different rules for different cultures, but we don't want to let the entrance fee here keep us from doing our important work. And you get the mediator to say, you know what, I'll take a chance on this as long as you're here. Some people have paid, yes, others haven't. Let's just reserve this to the end, and I will propose as the mediator, if we resolve this, a fair solution about the money. It's once people get in the room and they get out of the fighting arena and the mediator has them talking about issues, and they're what Victor and I call being in the field of understanding and good faith negotiations. Things change. Then you turn to someone and say, I know you're not used to paying and so on, but look what you've gotten here today and so on. Would you contribute to this and to this resolution so that everybody paid their fair share? But to fight that out beforehand keeps people often from peace, which they deserve. So good mediators create kind of an effective way to kind of get around money ruining the chance to get some peace. And that's best done. Usually you can work something out, especially if you get a deal.
Thank you.
Yes, sir. Yes, ma'am. Okay, last question.
Okay. Who else has a question?
See, people are, looks like you guys, you all did such a great job. You've answered all their questions. Anyway.
Okay, I thought.
Yes, go ahead.
Yes, sir, go ahead. Okay, I thought Salamatu was trying to ask a question. Okay.
I was trying to ask a question.
Okay.
This is Gloria.
Okay, Gloria, go ahead, please.
Yes. My question is, how do you mediate between people people of diverse and extreme culture?
Very good question. Thank you for that. You have to make them each comfortable first and feel safe. That's the role first of a mediator. And one of the ways you do that is by giving them some understand that you understand, you've studied, you've asked questions about their culture, you know that, and you say to them, I understand that this custom or this trait or sitting on this side of the room or being facing east or something is very important to you. And so we're going to try to accommodate that today. But you understand that the people who are here from another region, they don't have the same rules. So they're going to do it. We're going to try to accommodate them in a different way. And and we understand that you've been trained in your negotiations to be very cautious and very and not to bid very low and to stay very high. And we understand that the people from the other culture, or I understand, they don't like playing this Bazaar at Istanbul game. They want to get to it right away, or get into the field of real negotiations. There are other people who they have to try first for some crazy amount and bid low and play like I call it the Bazaar at Istanbul. They've got to play like that. And others, like the Japanese, for instance, culture, they would find that very insulting to make a high demand or a low ball offer. So they want to get to the middle right away. So you as the mediator have to demonstrate that you are aware of what their cultural dynamics are and what they're bringing to this. And then you masterfully, because you've trained yourself and so on, you create a forum that accommodates both cultures and both systems. And that takes some experience and creativity. But once people feel safe, you remind them that they retain control, that you can't impose a decision upon them, and that you at least appreciate what their traditions and cultures are. And that as many of them as you can accommodate, you will. There may be some where they're going to have to be flexible. But look, the other side is doing that too. Then you have a chance to break the cultural barrier. But it starts with people feeling safe, understanding the rules, and understanding that the mediator appreciates what their culture and their tradition is, even if he or she doesn't accept every piece of it in the mediation. And usually people grow and accommodate. But the key is they have to feel you understand them, that you appreciate that they've been raised a certain way and trained, or religiously they take their direction from the Quran or from the Bible or from some other tribal custom. And so it's you as a mediator get a chance to try to blend cultures and blend it to finding a fair deal. And it starts with understanding, and it starts with making people feel safe, that they're understood and respected. And when you do that, people grow and do very amazing things. It can happen. Yeah, I hope that answers your question. Yeah. Go ahead, Victor.
Thank you, Judge.
Thank you,
Thank you, Judge.
very much, sir. We appreciate you.
Yeah, Judge Dan is like a walking encyclopedia. Every time I'm with him, I don't need a textbook. I just need to frame my questions rightly, and that's all it takes.
Thank you very much for the honor of bringing him on board.
With oil company executives and Amazon Indians, Indians in the jungle. Wow. And made those and made a huge deal with those different cultures. Wow. The chief sitting there with his whole tribe around him, staring at the wall. Right. And 3 oil executives with ties on. Wow. It can happen.
Right. yeah, you heard from him. You heard from him. He's done it all across the world, and right now he's leading a movement of peacemakers across the world. So that's how a big deal Judge Danny is in the mediation and peace-making world. And in so many ways, yeah, and in so many ways, I think he is one of the modern founding fathers of mediation, not just in America, but across the world. And his track record really testifies to that. And so it's always an amazing opportunity and a privilege to get to have him say, a few words, even for 2 minutes.
we don't know what to say, but we are grateful that we had the honor. I think this set of trainees and mediators are fortunate, so to say, that right. They have one of the greatest influencers and founders of mediation come talk to them about aspects of mediation that is very, very important. So please put it on your record on the 1st of May, on Workers' Day. You have Mr. Winston train you, answer your question on during your training. I think that is sufficient criteria or CV for you to be able to gain access into some places. Thank you very much, Mr. Victor. I believe the participants are really excited and happy for that honor and privilege.
All right.
Thank you, sir.
Thank you too. Judge Danny, they all appreciate and honor you for carving out, the 5 minutes that you've taken to speak to them. They're really grateful. Thank you. All right. I think we can call it a day because we need to jump elsewhere.
All right. Thank you very much. That's wonderful.
Thank you, sir. Thank you. Thank you for lending us your ears and your time.
Thank you very much, sir. Thank you. Thank you. We are really grateful.
To the participants,
thank you. Yes, to the participants, without waste of time, we appreciate your patience for staying back to listen. Even though this is almost 30 minutes thereabout after the time that we're supposed to close, I believe that your sacrifice will actually be something that is worth remembering in your journey of being mediators. We thank Mr. Victor for creating time and bringing in this big heavy weather practitioner around the world to speak to us as the participants. As I say, and I will say it again, you are actually fortunate. So take note and browse about Mr. Winston, and then you'll be able to get to know more about him. And when you say that he was part of the people who train you that will be a very great honor, so to say. So thank you very much. Please, I will encourage you to adhere to the instructions written on your platforms. Please, some of the postings that we have done there, you can share it on social media, follow them up, tag, follow, share, encourage others to follow Settlement House, for more updates on ADR, on seminars, and all of those things. Then ensure that you also make the posting of each day, what you have learned, no matter how small. If it is just one part, you can share it on your social media handles, especially on LinkedIn. We really appreciate. We are going to send you the photographs, the snapshots, the screenshots. We'll send it to you so that you can use it to make your postings, and that will be very great. So tomorrow, let us come early. We are going to have practicals. When we have opportunity, we'll have up to 2 practicals, God willing and God helping us. So please try to turn in time, and try as much as possible to ensure that you charge your device, charge your laptop, so that if you are using the phone, you can switch from one to the other. Put in your questions ahead of time, read the simulations. If there is anything that you do not understand, send in your question and we'll be happy to attempt them. Thank you very much. In the absence of anything, I think we can call it a day. Bye.
Thank you, sir. God bless you. Bye.
See you tomorrow.
Bye.
God bless
See you.
you.
Bye. Have a nice night.